afternoon for participants from Asia and Southeast Asia. Good morning for participants from Europe, Middle East, and Africa. And good night for those who join us from America and Latin America. Since 2013, Beijing Arbitration Commission has organized this annual summit. The annual summit of Beijing Arbitration Commission has traveled the world. I counted that there are roughly 15 cities have received the Beijing Arbitration Commission and its team to talk about international commercial arbitration. Beijing Arbitration Commission really try to organize both in Eastern Hemisphere and the Western Hemisphere for the last 10 years or so. Unfortunately, with COVID, this will be the third annual summit that we are holding virtually. So we can no longer travel. I hope this COVID will soon behind us so that we can have on-site discussion about international commercial arbitration. Today, Beijing Arbitration Commission has lined up a group of excellent moderators, speakers, and commentators. Some are my old friends. With time constraint, I will not mention their name. But let me first introduce Dr. Chen Fuyong. I think Dr. Chen Fuyong may have more alumni than anybody else for this conference because he studied law first in Chinese University of Political Science and Law, and then moved on to Peking University Law School to get his LLM degree. After that, he finished his study in Tsinghua Law School as a PhD. He also worked as a visiting scholar in UC Berkeley. So with this full university, I'm sure he has more alumni than all of us. So without further ado, let's welcome Dr. Chen Fuyong to give his welcome remark. Dr. Chen.
Thank you, Mr. Tao, for your kind introduction. Distinguished guests, ladies and gentlemen, greetings from Beijing to each one of you watching this webinar, no matter where you are in the world. First of all, on behalf of the BAC, I welcome you all to the 2022 Annual Summit on Commercial Dispute Resolution in China. This year, we continue our cooperation with old friends. At the same time, we have invited new friends from Australia and Singapore to join us, injecting new blood into the annual summit. I would like to give special thanks to our co-organizers, Australian Centre for International Commercial Arbitration, Arbitration Foundation of Southern Africa, Asian International Arbitration Center, Charter Institute of Arbitrators, Cairo Regional Center for International Commercial Arbitration, JAMS, International Arbitration Center of the Astana International Financial Center, Center for Commercial Law Studies at Queen Mary University of London, and Thailand Arbitration Center. Thank you for joining forces with us in organizing this event. In addition, my thanks go to our supporting organizations, guest speakers, and all participants. Thank you for your interest and efforts in helping us to make today's event possible. The year of 2022 marks the 10th consecutive years that the BAC has organized a team of senior experts to compile the Commercial Dispute Resolution in China, an annual review and preview. This report is published globally in both Chinese and English. The BAC has also co-hosted the annual summit with our international partners since 2013. We have visited 13 major international arbitration hubs, including London, Paris, Stockholm, Vienna, New York, Hong Kong, and Singapore, just to name a few. Both the annual report and the annual summit have become important windows for people from all circles to understand the practice and development of commercial dispute resolution in China, building important exchange platforms for professionals in the industry at home and abroad. In recent years, under the changing global situation in a pandemic unseen in a century, commercial dispute resolution in China is facing new changes, confronting new challenges, and ushering in new developments. To reflect and make response to these new issues, we have arranged 4 sections for today's discussion: arbitration and mediation, construction and energy dispute resolution, financial and investment dispute resolution, trade and IP dispute resolution, focusing on different specialties and matters that have been raised in the annual report. Together with the panelists from diverse backgrounds, we will share with you the latest industry overview, key regulations and policies changes, analysis of typical cases, and observations on hot issues in the past year. We hope the audience in different fields might find the topics interesting and useful. Looking back on the path we have traveled and forward to the journey that lies ahead, the BAC will stay true to our inspiration in providing world-class dispute resolution services to our users around the world and creating platforms to facilitate mutual understanding between practitioners with different backgrounds. We sincerely hope to work together with all of you and give full play to alternative dispute resolution to safeguard international trade in commerce in these changing times. Lastly, I hope you will enjoy today's discussions. Thank you.
Thank you very much, Dr. Chen. Now, let me hand over to our first session's moderator, Professor Lucas Mistalis from Queen Mary University of London. I don't know whether Lucas has already online or not. If no, let me maybe invite the first speaker, our take over momentaneously the role of Lucas Mistalis to introduce the first speaker, Helena Shihong. She's a managing partner of Fonda law firm in China. I recall that she studied law in Renmin University in China, then in UPenn Law School. She's now vice president of ICC Court of International Arbitration. So Helen, you have the floor.
Thank you, Mr. Tao, for your kind introduction. Good morning, good afternoon, and good evening, ladies and gentlemen. I'm Helen Shi, partner of Dispute Resolution Team at Fangda Partners. I have a PPT presentation, so bear with me a second so that I can share the screen with you. Yes, we are here. First of all, I would like to express my gratitude to BAC for giving us the opportunity to prepare this annual review on commercial arbitration in China for 2021. We highly appreciate the BAC's efforts in preparing and publishing the annual review report on dispute resolution every year to record the development of arbitration practice and the change of rule of law in China. Today, I will take this opportunity to spend around 20 minutes to give you a brief introduction of our 40-page long report. I hope my presentation today will assist you to have an overview of the major events that happened in China commercial arbitration practice in 2021. My presentation will be 5 parts, which follow the same sequences as our report. I will give an overview, quick overview of the social and economic background. I will then introduce the major updates of law, regulation, and policies related to commercial arbitration in China. Thirdly, I will discuss the typical cases on judicial review of arbitration. Fourth, I will share my thoughts on trending issues in international arbitration. Lastly, I will conclude my presentation with a few remarks. Overview. 2021 was the second year of pandemic. The pandemic brought significant challenges for global economy. Given those serious challenges, many foreign arbitration institutions have experienced general decline in their caseload. However, due to the support from the Chinese legislative, judiciaries, and administrative authorities, the great efforts made by all arbitration institutions and arbitration practitioners in China, the arbitration practice in China did not stop its further development. So far in 2022, BAC, Beijing Arbitration Commission, has received more than 7,000 cases. This figure alone demonstrates the significant development of commercial arbitration in China. In the following part, I will start by introducing the major update of laws, regulations, and the policies. In our report, we summarized new laws, regulations, and normative documents issued by legislative, judiciary, and administrative branches in China, and also discussed the development of arbitration institutions and their new arbitration rules. I will only touch upon a few highlights here for today. Starting from the legislation, the release of the revised draft of the PRC arbitration law might be the most significant event for the entire arbitration community in 2021. The new draft brings important changes to the current arbitration law. In general, the draft confirms the stance of pro-arbitration by removing certain outdated provisions that no longer echo contemporary arbitration practice. For example, as shown in the point 2 on the slide, the draft removes the previous mandatory requirement that an arbitration agreement must name an arbitration institution, and the new draft emphasized that party autonomy should be the main consideration in determining the validity of an arbitration agreement. The draft law also adopts various international practice from the model law. For example, as shown in point 3 and point 4 on this slide, the draft established the competence and the competence principle and allows the arbitral tribunal to order interim measures. In addition, the draft confirms that foreign arbitration institutions can set up business operations in China. All those changes show the commercial arbitration in China will be directed to a direction towards international arbitration. Turning to the judicial support and administrative support for arbitration in 2021. First, as you can see from the slides, the Supreme People's Court issued two major judicial interpretations. The first one provides clarification regarding the mutual enforcement of arbitral awards between mainland and Hong Kong. It is clarified that if the respondent is domiciled or has enforceable access in both mainland and Hong Kong, the applicant may apply to the courts of both jurisdictions for enforcement at the same time. The second document deals with the reporting and verification mechanism in PRC courts for judicial review of the arbitration. A unique mechanism in PRC court to make sure that arbitration agreement and arbitral awards will only be set aside upon the review of the higher level of courts. In administrative front, we have noticed that arbitration as an effective method to resolve dispute is recognized and supported by various PRC governmental authorities. For example, the China Securities Regulation Commission and the Ministry of Justice jointly issued the opinion on conducting the pilot program of arbitration in securities and the futures industry, establishing a pilot arbitration mechanism for resolving related disputes. Shenzhen and Shanghai have already set up securities dispute resolution centers following the issuance of this opinion. Another example of administrative support is that Beijing Justice Bureau issued the administrative measures for registration of business offices of foreign arbitration institutions in Beijing, providing guidelines for foreign arbitration institutions in establishing its business operations in Beijing. Latest development concerning arbitration rules. A number of arbitration institutions, including Beijing Arbitration Commission, have amended their arbitration rules in 2021 to adapt to the changes required in practice. There are several highlights of the amendments to be noted. The first one and the second one, remote hearing or virtual hearing and service by electronic means is to respond the need to deal with to handle the arbitration proceeding during the pandemic. And the BAs also in the amendment rules mentioned that the presiding arbitrator can be appointed by the two arbitrators appointed by the parties. BAs also reduced the maximum fee that can be charged by the institution. In addition, BAC also issued operational guideline on the adoption of hourly rates for arbitrators' fees to provide guidance on hourly fee basis charge. I believe BAC is the first arbitration institution in China promoting such practice, which will make huge differences comparing with other Chinese institutions, in my view. Other arbitration institutions and international organizations also launched new rules, such as CMAC, ICC, and UNCETRAL, you can, review our written report for the details. Typical cases in judicial review of arbitration. We have studied a large number of judicial review cases and selected 5 representative cases for our readers in our report. For today, I would only share one case concerning the appointment of arbitrator in multi-party arbitrations, as I believe the appointment of arbitrator is the most important step in the life cycle of an arbitration procedure. This is a case decided by the International Commercial Court of the Supreme People's Court in 2021 in a setting aside procedure. The arbitration agreement provided for 3 arbitrators, and each party shall appoint 1 arbitrator. The claimant appointed 1 arbitrator, but the 3 respondents claimed that they could not agree on a joint basis to appoint 1 arbitrator, and requested CTAC to appoint all 3 arbitrators according to CTAC arbitration rules. CTAC, during the process, informed the respondents that if they could not jointly appoint 1 arbitrator, CTAC would appoint 1 for them, while reserving the right to object. The 3 respondents finally jointly appointed 1 arbitrator. After the arbitral award was rendered, the respondents applied to the Supreme People's Court to set aside the award, arguing that the composition of the arbitral tribunal was inconsistent with the CTAC arbitration rules. One additional element I should add is that the 3 respondents are under the same shareholding control. The issue in this dispute was very clear. Should CTAC appoint all arbitrators for both claimant and respondents? Does the parties' agreement override the arbitration rules in terms of the constitution of the arbitral tribunal? The SPC's ruling in this case is very inspiring. Of course, they did not support the respondents' application to set aside the award should be enforced. The court said first, the SPC, the court applied the validation principle, saying that contract terms should be interpreted in a manner that preserves their validity whenever possible, and it should not be interpreted in a manner that that preserves their validity whenever possible, and should not be interpreted in a manner that renders the provisions redundant or meaningless. In this case, because the party agreed that both parties have the right to appoint 1 arbitrator, then there is no reason to compromise the claimant's right to appoint arbitrator for all parties, just because the respondents could not jointly appoint their arbitrator. So in this case, I think the SPC's ruling demonstrates that SPC's attitude towards the party's autonomy. If party autonomy is in conflict of arbitration rules selected by the parties, then parties' autonomy should prevail over the arbitration rules. This is a case I would like to share with you. I think it's very important in practice. The trending issues in commercial arbitration. We have selected 2 issues for discussion and analysis in our report. The first one concerns foreign arbitration institutions administrating arbitration in China. The second one relates to revisions to the system for non-enforcement of arbitral award in the revised draft of the PRC arbitration law. For today, I will share my observations with you regarding the first issue, the legal basis, the practice, and the outlook of foreign arbitration institutions conducting arbitration in China. Whether foreign arbitration institutions can administrate arbitration in China has long been a debated issue in Chinese arbitration community. This is because the 1994 arbitration law, which is currently effective, this arbitration law leaves no room for foreign arbitration institutions to administrate arbitration in China. However, Chinese judicial practice has undergone many changes and developments in the past decade. We have summarized the milestone cases here on this issue in our report and also in this. Following the Lonely De's case in 2013, confirming the validity of ICC arbitration in Shanghai arbitration agreement, and the Daesan industrial gas case in 2020, and also Brentwood case, it has become clear in judicial practice that foreign arbitration institutions is allowed to conduct arbitration in China, and the arbitral awards made by foreign arbitration institution within mainland China as the seat of the arbitration shall be regarded as foreign-related arbitral awards. So I think the judicial practice is very clear that a foreign arbitration institution can administrate arbitration in China. So can foreign arbitration institution establish its offices in China? This is a sort of administrative issue. In terms of the policies supporting foreign arbitration institution to establish its office, I noticed that many authorities have issued relevant documents encouraging foreign arbitration institutions to establish its operations in China. But there are still missing pieces in the puzzle. Is there any law, any legal basis for foreign arbitration institutions to set up offices in China? The revised draft of arbitration law actually completes the puzzle. Article 12 provides that foreign arbitration institution may establish business operation in China. This article, if the draft law passed, will provide the legal basis for foreign arbitration institutions to start its China operation. Outlook for foreign arbitration institutions arbitrating in China. I have just summarized our answer to the questions I listed here in this slide. The answer is affirmative. So the message I would like to send is that there will be no longer legal impediment for foreign arbitration institutions to conduct arbitration in China. We could expect arbitration institutions to regularly conduct arbitration in China in the future. And this will bring more opportunities to Chinese arbitration institutions, arbitration practitioners, arbitrators to further develop Chinese arbitration to be more international. Concluding remarks. This is a final session. It was really, lucky for us to have the opportunity to write the annual report for 2021, because there are so many remarkable changes and events happened in 2021. We are happy to say to be the witness to see the revision of the arbitration law was issued, and we are impressed by the innovation of the arbitration institutions in amending their rules and guidelines. We are also grateful for the judiciary and administrative support for arbitration and for the efforts made in welcoming foreign arbitration institutions to conduct arbitration in China. The world also recognized over years of efforts. In the arbitration survey conducted by Queen Mary University of London in 2021, Beijing was ranked the 6th on the list of most favored arbitration seat. Shanghai ranked the 8th. I look forward to the continued faster development of arbitration in China. I would also like to take up this opportunity to raise several expectations. I do hope that the revised draft of the Chinese arbitration law can be approved soon, and the relevant supporting laws and regulations will also be updated to ensure that the smooth implementation of the new arbitration law. Second, I hope that relevant authorities can set forth detailed guidelines or rules for registering foreign arbitration institutions. Third, I hope that PRC courts can continue their support for arbitration so that Chinese arbitration institutions, such as Beijing Arbitration Commission, can develop in a more international, efficient, and transparent direction. I think my presentation will end here. Thank you very much for your patience. Thank you. Mr. Tao?
No, Ms. Shi, I'm taking over from Mr. Tao, so that's Lucas Mistelis. Thank you very much for your excellent presentation and for summarizing such substantial content in only 20 minutes. I wanted to make perhaps two comments, one of which might come even as a question. I note particularly the, let's say, the more outward-looking developments in China in the last year, sort of the interaction with foreign institutions, and also not with sort of a lot of interest, the case that you mentioned about the appointment of arbitrators in multi-party proceedings. And as you know, this case is very different from something that the French courts have decided many years ago in the Siemens and Datco case. And I think perhaps the Chinese case is correct. Actually, doesn't open the floodgates of the Datco case. But do you think that in the revision of rules in China, there will be much more accommodation for multi-party proceedings? So do you think there's is that a point of debate within the arbitral institutions?
The case you mentioned, the French case, and also the Chinese case I shared today, I think, different cases have different facts pattern. This case, as I mentioned, the three respondents have the same shareholdings. I think that's the major difference. If the multi-party, the two respondents or three respondents have conflict interest, not under the same shareholding control, maybe CTAC will make a different decision. But I think, I think CTAC is the only arbitration institution who has this mechanism, which is quite similar to ICC mechanism, which allowing the institution to decide at what time both party claimants and the respondents, especially when multi-party involved, all three arbitrators should be appointed by the arbitration institution. So yes, it really depend on the case scenario.
Because, for example, the LCIA has taken the view that it might be artificial to consider that all respondents jointly or all claimants jointly can make an appointment. So in all of these cases, the LCIA has routinely made appointment of all three arbitrators, which was the suggestion of the respondents in that case. But of course, as you say, despite them being separate entities, you could trace sort of the ownership. So thank you very much. This was really very good. And I commend your report. I have read it, and I hope sort of a lot of other people would read it as well. Then let me turn to Ms. Zhao Fang, who is going to give us the second part of the report. She has a wonderful experience in practice. She's also qualified in England and Wales, and she's acted in both arbitration and mediation, and is a qualified mediator. I think the focus, Ms. Zhao, will be on mediation today. So over to you.
Thank you, Professor Lucas. Nice to see you again. So good morning, good afternoon, and good evening, ladies and gentlemen. Thank you very much for attending this session. And I'm extremely pleased to be here and on behalf of the BAC to share with you my report on the annual review on commercial mediation in China. So in this session, actually, I'm going to share with you my observation as an author in 4 sections. So first of all, for the convenience for you to understand my report today, I'm going to give you a very short introduction of the mediation system in China at the moment. And secondly, I know that people are generally fond of figures, so I tried my best to collect some data and from the BAC's last 5 years report so that we can make a comparison and see what is the real development during the last year. And thirdly, there have been many innovation actually in this area in the past year. So I just selected a few to give you a flavor. And lastly, despite all the achievements and developments we made last year, there are bound to be some pitfalls in this system that we need to look at and resolve in the future. So in the last part, I'm going to have a little bit chat with you over those issues. So this is my roadmap, and I hope they are helpful to you for today's session. And first of all, a very brief introduction of the system. So if we look at the mediation system of PRC, we had now actually 2015 could be said as the commencement year of the modern mediation system in China. Because in that year, the State Council rendered the opinions on the improving the diversified mechanism for dispute resolution. So for today's purpose, I'll just use DMDR to stand for the diversified mechanism for dispute resolution. So in the opinions, the State Council actually mentioned mediation as one of the pillars supporting this DMDR system. And also the State Council encouraged the general public to integrate all kinds of mediation resources to set up industrial or professional mediation organization. And after the year of 2015, in the next year, in 2019 and in 2021, actually the Communist Party and also the central government released more documents on the blueprint of the DMDR system, and under which the importance of mediation becomes greater and greater. So at the same time, actually, the SPC Supreme People's Court rendered many judicial opinions to implement the central government's public policy on the DMDR system. So what is DMDR system exactly? So DMDR system is aiming to integrate litigation and other ADR method together into one stop and to provide a very efficient dispute resolution service to the users. So the establishment of DMDR system composes of 4 parts: platform establishment, supporting systems, procedural arrangement, and security to all these works. But now China is mainly focusing on the platform platform establishment is trying to link different parts together. And the work under other three sessions were only lightly touched upon. That is because only if the system has been established and running smoothly for some time can the legislator and also the judicial supervisor know how to make rules to regulate all the mediation activities. But looking at this chart, actually, we can have a flavor how important mediation is in this DMDR system, because almost in every block, we can see some element of mediation. So that is the current status of the mediation system in China at the moment. So second, let's look at some developments of commercial mediation in China in the last year. So I collect all the data reported by BAC in its last 5 years annual review on commercial mediation. So I know that there are a lot of numbers. So for today's purpose, I only need the audience to concentrate on the green and red ones. So this part is the figures from the court. So we can see that in 2017, 5 years ago, the case mediated by the court is approximately 14 million cases. But in this year, the total number is close to 24 million. So it has a rapid increase. So regarding the mediation organization, the number of the mediation organization almost doubled from 2020 to 2021. And also, if we take BAC as an example, 5 years ago, the cases settled by mediation in BAC was close to 400 cases. But in the last year, actually, the number almost tripled to 1,200 cases. So all is very impressive increase. And I know that in the previous slides, we can't see, the development of commercial mediation because, all the mediation on the platform of the court include civil, administrative, and also commercial mediation. So next two slides will have a bit more regarding the real world of commercial mediation. So here we can see to the last year, CCPIT has established 59 mediation centers nationwide and administered 2,000 cases per year. And in contrast, ACFIC established more than 3,000 mediation centers all over China and had administered more than 130,000 cases since 2018. And then let's step into the world of arbitration. So we can see that last year, almost more than 410,000 cases were accepted by the more than 270 arbitration institutions altogether. And among those cases, more than 22% cases were actually settled via mediation. And if we take the individual arbitration institution for an example, the settlement rate, which is the cases either settled by mediation or withdrawn after settlement by the parties, the settlement rate ranges from 18% to 38%. So all reflect, a stark increase in the number of the mediation case. So how have we achieved such a rapid development, such a rapid increasement in the mediation system? That is because we have the one-stop service, one-stop DMDR service. This is a chart provided by Supreme People's Court in the last year. So on the right side is a litigation channel. So whenever a case is before the PRC court, the court has two choices. It can either, upon the parties' consent, send over the case to the left side, which is the ADR methods. So the court can send over the cases to the ADR system and ask the party to reach a settlement by negotiation, mediation, or arbitration. Or the court can retain the case within its own system and ask its own mediator to mediate the case and try to reach a settlement. So no matter the case is settled on this part or on the right part, then the parties can all, holding this settlement agreement they reached and ask the court to give a judicial recognition of the settlement agreement, that is, issue a ruling which grant mandatory enforceability of the settlement agreement so that the party can resolve the dispute once and for all, which is a very effective method for the dispute resolution. So now we come to the third part regarding the innovation in practice. So in this part, I especially want to talk about a little bit more about CICC, that is China International Commercial Court. So I still remember that when we did not have COVID in 2019, I was in London to attend the GAR summer session, and I was assigned the task to have the introduction of CICC. So my foreign friends were so interested in CICC, and they kept on asking me, how would this one-stop platform work, and how would it look like? So my answer was, I don't know. We still need a bit more time to understand how it goes. But now we really know how it goes, because last July in 2021, the one-stop platform actually launched on the official website of CICC. So that is how it looks. So you register on the official website to use your own account, and then you can upload all your documents and process your litigation, filing the case with the court of CICC. But at the same time, actually, you can immediately, after filing of the case, use the same account to apply for a mediation here. And then you can select either mediate the case by the expert committee of CICC, many experts in law, and also you can select to mediate by the authorized mediation center of CICC. So I share with you the interface of the CICC online mediation center. That is how it looks like. So on the left side is the PC end. On the right side, it is the app. So you can use your phone to administer, the process of your mediation. So I happen to have a case filed with CICC this year. So I asked my colleague to share with me, her account so that you have a bit flavor of, how CICC works in this scenario. So we all know that CICC has now 2 authorized mediation institution, commercial mediation institution. One is the Commercial Mediation Center of CCPIT, and the other is Shanghai Commercial Mediation Center. So in order to provide our foreign friends and other users more choices, the SPC, Supreme People's Court, rendered many judicial opinions last year and urging, the Chinese parties to invite the worldly famous International Mediation Center to establish their branches in the free trade zone in China. So we all know that we now have 21 free trade zones all over China. So probably next step, of the construction of mediation system, we will aim at inviting more, mature international mediation centers to come to China and have their permanent establishment in China. So that's what about CICC. So for the interest of the time, I'll just skip this page and directly jump into the discussion about the innovation in legislation. So last year we had amended the Civil Procedure Law, the CPL, to further boost the mediation activities in China. So I think that most of you are aware that before 2021, under the CPL, we only have the concept of people mediation. So people mediation mainly refers to those mediation of civil matters, so not necessarily linked with commercial mediation or administrative mediation. So the amendment actually under the CPL expand the scope of mediation organization, including commercial mediation organization and also administrative mediation organization, IP mediation organization, etc. And also, as I mentioned, the court now is empowered to invite mediation at its own initiative. So the amendment of the CPL also reflected this change. And lastly, because there is a very convenient method of enforcing the settlement agreement reached by mediation. So the CPL actually expands the jurisdiction of the court, which can render the ruling. So now the parties can go to the litigant's domicile, location of the public, or place of mediation organization, and ask the local court to render a ruling of recognizing the settlement agreement reached between them. So this amendment will also enhance the efficiency of commercial mediation and other mediation. So lastly, I believe I still have 4 minutes, so I will just chat with you a little bit about the pending problems. So as we discussed just now, now in China, there are many kinds of mediation: civil mediation, commercial mediation, administrative mediation. But unfortunately, we don't have any guidelines for the mediators, activity like code of conduct or accreditation procedure, certification procedure. We don't have the standard operation method for the mediation organization. We don't know how to provide standard training session to all these mediators. And we don't even have, the standard fee charge rate for the mediation activities, how to running it as a business. So we are lack of, those guidelines. So the legislator or the SPC, the judicial supervisor, will need time to formulate those rules and then boost the mediation activities in a much healthier way. So that's the first issue we need to look at in the future. And the second problem is sham mediation, that is mediation in bad faith. So all of us have seen the figures just now. So we have abundant, so many cases mediated every year. And then they're bound to be bad guys, cooperated with each other, trying to mediate and try to damage the third party's due interest. So how should the court regulate those mediation activities, especially those that the court recognized and rendered judicial ruling in recognition? So if the court refuses to grant any remedy to the parties or to the third parties, then the judicial credibility will be damaged. But if the court is too ready to grant remedy, that is to set aside the ruling itself reached, then it will damage the efficiency of mediation as a very useful alternative dispute resolution mechanism. So it's all about balancing the interest. So this is something the court needs to pay attention and evaluate the facts under each case at the same time, and also, try to formulate some standards for the mediators or for the parties to obey. That's a second question. So lastly, the issue is we are now a member of Singapore Convention, but we still don't know how to enforce, international mediation agreements in accordance with the Singapore Convention. I believe that we are still a long way to go because we need to formulate our own domestic rules for mediation in China. And then we can align those practices, domestic practices, with the international practices. And only then we will know that how to set forth a standard for recognizing, the international settlement agreement reached by international commercial mediation. So that's something that we will look at in the future. So I think that ends my report today, and thank you very much for listening. Thank you.
Thank you very much, Ms. Zhao. I think there are two main themes that come out of your presentation. One, of course, is expansion or growth, and the other is innovation. I think both of them are quite important in so many different ways. If I may attempt two comments and one question. One comment comes from my experience as for many years, the academic chair of the Civil Mediation Council in the UK, where one of the big tasks we had was to look about mediation training providers and see what are the appropriate standards and what are the minimum standards. And actually, in so many ways, the UK is so much smaller than China, also perhaps as a mediation market. And then we were talking to a dozen rather than hundreds of thousands of providers. But I wonder whether that innovation means that there's a much more increased, for lack of a better word, institutionalization of mediation in China, or even, God forbid, perhaps that's even another inappropriate phrase, some sort of an emerging westernization of mediation in China. Because effectively, when one speaks about standards, about accreditation, that seems to be very much sort of what the practice has been in the US primarily, and then in Europe. What is your reflection on that?
So my reflection is that, because China actually does not necessarily have the same style of mediation as Western has. So we know that in the Western, I'm also an accredited mediator, trained in London, so I know how it goes. But it's quite different because the culture difference is here. And, actually, I believe the Supreme People's Court is still waiting for the right timing to formulate our own rules, because last year I didn't introduce in my PPT, but it's also a topic because the SPC rendered a very, very general and basic guidelines for the mediation activities, for the requirements, required quality actually of mediator. But that is, the requirement is so straightforward and simple, like you should be integrated, honest person, and you should have the necessary, profession knowledge. So I don't think that is real standards at the moment. But I think that because we are on the road and we need to see how it goes and what is the common practice standards accepted by the Chinese people and also the mediator. So probably I think that we might have a hybrid style of mediation, incorporate, Western style and Eastern style together. Then we have our own style. That is my observation.
And perhaps that's the future. So thank you very much. Then for this session, we have two commentators. We have David Hubner, who is a very experienced arbitrator and mediator, having spent quite a bit of time in Asia Pacific as an ambassador of the US to New Zealand. And we also have Helena Chen, who has been doing that part of the presentation some years ago. I think one of my first summits, perhaps in 2014. And now she has set up her own practice. She was with a different firm at the time. Is Helena, are you going first? Or David Hubner goes first?
According to the agenda, David would go first.
Yes, that's good. That was my impression.
Either way is fine with me. Thank you.
Very good. So then David, you can go first. Thank you.
Thank you. Thank you to Dr. Chen, first of all, and BAC for again inviting me to participate in the annual summit. I was based for 4 years in Shanghai and ran my international arbitration practice from an office that I established there. And I continue to regularly sit on cases involving mainland and Hong Kong parties. So developments in China ADR are of particular interest to me. I'd also like to thank and congratulate all of the authors of the chapters in the annual review for their excellent work. Because of that high quality work, I note that with respect to the substance of today's discussion, there is perhaps little on which I can offer non-redundant commentary. Both the arbitration chapter authored by Helen Shi and the mediation chapter authored by Zhao Fang are comprehensive, excellent, and very useful. Similarly, their two PowerPoint presentations covered the landscape very, very comprehensively. So I would like to make just a limited number of comments and flag a couple of additional issues for future consideration. First, with regard to arbitration, I view 4 of the changes in the draft revision of the arbitration law as particularly powerful, including in terms of expanding and growing international arbitration in China. Specifically, first, the removal of the provision that arbitration is only available to disputes between, quote, subjects with equal status, end quote, which limited the scope of arbitrable disputes and created what I consider to be meaningful interpretive uncertainty. Second, the express affirmation of the competence principle, particularly important in facilitating process efficiency and certainty. Third, the empowerment of arbitrators to issue interim measures, the express empowerment of arbitrators to issue interim measures, although it appears that there might still be some uncertainty about the scope and standards for court intervention after a tribunal orders such measures. And fourth, the removal of the language invalidating arbitration agreements if no administrative institution was clearly named in the clause. Also, in terms of the BAC rules, it's very important that changes have been made that expressly empower arbitrators to order online proceedings and determine efficient method of service. In terms of cautions, just a couple of issues struck me. First, I query whether the provision in the draft revision that permits non-enforcement of a final award for, quote, violation of the public interest, end quote, injects some uncertainty into the process, given how expansive and perhaps situationally elastic that term might be. I'm similarly curious about the provision allowing a non-party to initiate a tort claim in court if it concludes that a final award is, quote, erroneous, end quote. I'm particularly curious with respect to against whom such a tort claim might be brought. Finally, I'd just like to quickly make 3 general points about the future. First, what matters most are not written words, but implementation. And I look forward to seeing how the draft revisions are interpreted and applied. Second, I would urge all relevant parties, including arbitral institutions and government regulators, to consider the matter of arbitrator performance evaluation and transparency, which I rarely see dealt with in arbitral innovations. From my own prior experience as an advocate, I know that one of the primary Achilles heels of our sector remains the lack of reliable, accessible information for parties facing decisions on which arbitrators to select. That challenge becomes exponentially more difficult as arbitrator ranks swell globally. And finally, I would urge institutions, government regulators, counsel, and arbitrators to embrace rather than defer cultural evolution in the ADR sector in response to accelerating climate change, a topic that is often left out of revisions in arbitration practices and rules. International arbitration is carbon intensive, and the COVID pandemic, which I believe to be the first of a likely series of global health disruptors, has shown just how efficiently cases can be heard remotely and with electronic submissions. I see no good reason for us to return to carbon-intensive business as usual. Thank you again to BAC for inviting me to participate today, and to the authors and presenters who have done such superb work on this year's annual review. Thank you. Professor, you're on mute.
I thought I would have learned it after 2 years of the pandemic, but obviously the mute button sometimes remains. I was thanking you very much, David Hubner, for some very insightful comments and helping us to look into the future. I think is one should not lose sight of next generations and what we can do to make sure that they have a better life. And therefore, my final part of that part is to invite Helena Chen to provide her comments.
Thank you very much, Professor Ms. Tellis. It's really nice to see you again, albeit virtually. I'm Helena Chen, the founding partner of Chen and Chang Attorneys at Law, 陈锡家仲裁国际律师事务所. It is my great honor and pleasure to participate in this panel. I'm very grateful to the organizer, Beijing Arbitration Commission, also known as Beijing International Arbitration Center, for its kind invitation. I'm very happy to be involved again in this BAC annual event. Before COVID, I was one of the speakers when BAC organized the same event. At that time, as Jingzhou mentioned at the very beginning of this conference, we could travel to several cities in Europe and have drinks with our friends there. Although we now can propose a toast virtually, I echo Jingzhou and very much look forward to the day when we can freely travel across the borders and meet our friends in other jurisdictions in person again. Despite of the restrictions of COVID, there have still been many significant developments in arbitration and mediation in mainland China, as well reported by Ms. Helen and Ms. Zhao Fang. Regarding arbitration, I'm particularly interested in the possible development of foreign arbitration institutions administering arbitration cases in mainland China. I think this could be one of the driving forces motivating local arbitration institutions to further improve their services to be comparable with or even better than the current international arbitration practices. I noted that according to Article 77 of the draft amendment to PRC Arbitration Act, an application to set aside an award rendered by a foreign arbitration institution in China is to be heard by the court located at the venue of the arbitration. I agree to this approach, and I hope that the Taiwan court or legislators can adopt this approach as well. Currently, and maybe unfortunately, there have been several Taiwan court precedents holding that a Taiwan court located at the venue of the arbitration does not have jurisdiction to hear an application to set aside an award rendered under foreign arbitration rules in Taiwan. Then turn to mediation. The number of mediation cases in China is huge, and the government's efforts to promote and facilitate mediation are very obvious, I'd say. And there have been many rules, regulations, and the letters on mediation issued by various judicial or administrative entities as listed in the table attached to Ms. Zhao Fang's article. Be that as it may, a commercial mediation act is still wanting. We have a similar situation in Taiwan. While we have several articles in Taiwan civil procedural law on mediation, we also have several rules and regulations on mediation, but we do not have a basic mediation act yet, or a civil mediation act yet. As the current chair of ADR Committee of Taiwan Bar Association, I have been invited to act as an advisory board member to advise the drafting board of the Civil Mediation Act organized by the Judicial Yuan in Taiwan. A draft Civil Mediation Act has been circulated for soliciting public opinions. It seems that people on both sides of the strait are more or less on the same page. perhaps the drafting board members on both sides of the strait can exchange their views and learn from each other's experiences, as we are both civil law jurisdictions and share the same cultural background. I think mediation is, to a certain degree, heavily influenced by the relevant cultural backgrounds. And I think I will just pause here, and thank you very much for your kind attention.
Thank you very much, Dr. Helena. I think we are running out of time. It would have been very good if the presenters had an opportunity to reflect on that. But I'm grateful to BAC, BIAC for their invitation, and I think the report gets better and more interesting every year. And there's so much to take away. So perhaps the best is to just thank the presenters and the commentators and allow everyone a bit of time to reflect before the next session. Thank you very much. Over to you, John.
Thank you, Lucas. Good afternoon, everyone in China. This is and good day to our colleagues joining us from around the world. I hope you can hear me all okay. My name is Joe Tirado. I'm a JAMS mediator, arbitrator, and neutral evaluator, and co-head of international arbitration and ADR at Spanish and Latin American law firm Garrigues. It is my great pleasure and privilege to be the moderator for this second session of today's program. And following on from the general overview that we've just been hearing on the state of commercial arbitration and mediation in China in session one, we should be focusing in this session on the review of dispute resolution in China in the construction and energy sectors. And we're going to deal with both of those separately. Firstly, we shall be considering the construction section, and Mr. Xu Jun, forgive me if I've mispronounced your name, Mr. Jun is Managing Director of Frontier and Partners in Beijing. He has been involved in more than 160 arbitrations under a variety of national laws and arbitration rules as counsel, arbitrator, and adjudicator all over the world. Commentating on Mr. Jung's presentation will be Professor Dr. Narong Lumbudnak, again apologies for any mispronunciation, who is an adjunct professor at the Asian Institute of Technology in Thailand and formerly a professor of Kwon Cain University. He's a serving chairman of consulting firm called Future Engineering Consultants based in Bangkok. And Professor Lumbudnak has over 40 years of experience in construction management and project management, as well as sitting as an arbitrator. We'll then next turn to our second topic, which is the consideration and review of energy dispute resolution in the energy sector. Mr. Leslie Zhang, who is the General Counsel and Vice President of United Energy Group Limited, will provide an introduction or an overview of that section. Mr. Zhang has over 20 years experience in oil and gas industry and has extensive experience representing his company in cross-border commercial disputes and international litigation. He's clearly successful at what he does because he's been previously recognized as one of the top 15 general counsel in China and as one of the best in-house counsels in the Asia-Pacific region. Unfortunately, you may have seen in a previous iteration of the program, Mr. Hilary Lau of Herbert Smith Freehell, who was originally scheduled to join us today, is unable to do so. However, I am pleased to say that his colleague, Mr. Charles Wong, can. Mr. Wong is a senior associate of Herbert Smith Freehills. He has experience on a wide range of complex cross-border transaction in the energy, resources and infrastructure sectors. In particular, Mr. Wong advises clients on their investment and development in the oil and gas, LNG, renewable and power sectors, and has experience throughout the upstream acquisition, field development, production, transportation, storage and distribution. If I may, can I refer you to the handbook for the detailed biographies of each of our contributors today? But I think it's self-evident for what I've said already. We have a stellar panel to speak to us today. Given that there is a lot to cover in the very short time that's available, I shall hand over first of all to Mr. June to get us started. But I just want to point out that we are extremely fortunate to have Mr. June this morning because he is actually one of the co-authors of the chapter on dispute resolution in the construction sector. So he's extremely well placed to make this presentation. And without further ado, Mr. June, if I can hand over to you. Thank you, sir.
Yes, thank you, Mr. Joseph, and welcome everybody, and thank you all of you for joining us in the panel 2. And our today's session deals with the annual review on the construction dispute resolutions in China for the year 2021. And it goes without saying that in the year 2021, in the field of the construction dispute resolution will be the following major events. The first is the coming into force of the Civil Code on the 1st January 2021, and especially on the construction sector, the coming into force of the new Judicial Interpretations 1 on the construction contract published and released by the SPC, the Supreme People's Court. And the third major events is that the implementation of the EPC contract for the construction projects is a kind of a model contract form. It will be implemented from the 1st January of 2021. And the next major event is the cancellation of the qualification certifications for the construction cost consultations. It focuses on the market organization for the construction cost consultations in China, not only in the court proceedings, but also in the arbitration proceedings. And the fifth major event is the construction contract disputes has become an important part of the arbitration cases. In the BAC, Beijing International Arbitration Committee or Commission, there's about it has occupied or amount to a very important part of the arbitration cases in China, not only in the Beijing BAC, but also in the CITEC and other arbitration institutions in China. So this is the first one. The second, except the second tier of the laws, like Civil Code of the People's Republic of China, in the particular construction sector, the law of the People's Republic of China on the Prevention on the Control Environmental Noise has been released on the 24th December 21. And in a summary, or in one word, the main feature of the law is that the first ever in China history, the noise pollution prevention covers not only the urban, but also the rural areas. To some extent, it reflects the environmental requirements for the modern urbanization in China in the past 4 decades. And the second is the major events on the construction sector is the releasement of the provisions on migrant workers' payroll security in construction industry on the 17th August 21 by relevant ministries of China. The Article 11 of this law requires the contractor to provide a payroll deposit by way of security of 1% to 3% of the construction contract price to the deposit in the bank as the securities to pay the payroll to the migrant workers and to protect the workforce in the construction sectors in China. And if the contractor fails to do so, the relevant government sector will issue the warning notice to the contractor or to also cooperate to the bank, and the bank, after receiving such notice, will pay the payroll to the workers directly and without agreement by the contractor. So this one will protect the migrant workers in China in a very effective manner. The third one is the Bulletin on Capital Performance Administrative Measures of a specific bond to the local governments. And based on this bulletin, and it introduced measures to control and to manage the local government's debt risk and to give some bottom line and administration measures and how to manage the local government's debt risk in the development of the societies and the economic. And the next is the case study in my report. And the 3 cases are introduced by me. And the first case is concerning about the validity of the subcontract for, international construction works if the contractor assignment of the contract to the other, and in this case, in my review or in the tribunal's review, the core elements to decide the validity of the subcontract in question should be the scope of the application of the second tier law, the construction law of China, the Article 2. The Article 2 of the construction law states that this law is applied where the construction activities is within the territory of the PR China. This principle has been supported by the Beijing Falls Court because one of the parties appealed the case to the Falls Court to withdraw the arbitral decisions. However, the court has ruled to dismiss the appeal because the application of the Article 2 of the construction law in China is really depends on the arbitral's description. And I have to mention that in the case number 3 is the application of the second provisions in the judicial interpretations by the SPC in China relating to the time bar clause for the contractor's claim. As far as all well known, in the FIDIC contract, it provides the 28 days time frame for the contractors to claim against the employer. And if the contractor failed to give the notice, and then the contractor claim will be time barred. So this is the something happened internationally and domestically. However, in the second provisions, it remains to provide that the reasonable defense from the contractor has the basis to defense against the employers for his entitlement on the additional cost and the extension of time. However, what is the reasonable defense is not clear at all in the judicial interpretations released by the SPC. In this case, the tribunals give some explanations as to how to explain what is the reasonable defense in construction sectors. So this is the case of the number 3 we have to emphasize in this session. And the third one is the hot topic in this industry. We have to pay some attention that just several or 6 items of the hot topics in the construction industry, not only stemming from the application of the civil code and the general contractor delivery system, the application of the model EPC contract forms. However, in my speak in today, we have to emphasize the dispute adjudications in China. As far as I know, the first ever dispute adjudication comes China is in 1990s. In the 1990s, when 2 mega hydropower projects was built in China, like the name, I cannot remember well. The mega project was financed by the World Bank, and some adjudicators are introduced by the World Bank, and from Germany or from England, and they formed a dispute review board for the project. And finally, the dispute adjudications was taken effect and to give some solutions on the construction disputes in the course of the construction works. And this in the 1990s, the 2 major cases has been appeared in China for the dispute adjudications on construction sector. In the recent case, that is in 2021, the CITEC, China International and Economic Trade Arbitration, has implemented a dispute review board to the one of the major projects in China, and more than $1 billion civil works in China. And within 2 weeks, the dispute review board, the DRB, has given the suggestion or recommendations to the parties, and then parties will be satisfied to the decision, and the works will go on smoothly without interrupting by those disputes. And this I have to emphasize on the dispute adjudications in the construction sector in the latest case in the 2021. And this is the case, and the conclusion is that for my speech, and it goes without saying the civil code under the new judicial interpretation of construction contract. And number 1 were introduced by the China by the SPC and in the following years, and that will be the some issues or lot of the law will be occurred in the following years. So the this is my interpretations for the my speak. Thank you, Mr. Joseph, for your timing.
Thank you very much, Mr. Jun. If I may, in the interest of time, let me pass straight over to Professor Lung Buknak for his comments on the presentation. Professor?
Oh, sorry, I have to withdraw.
I'm afraid you're, yeah.
Thank you, Mr. Joseph Tirado. And thank you, BAC, in inviting the Thailand Arbitration Center to join this event. We learned many things from PR China. PR China implement a new law regarding the construction contract. It's very important to develop the construction industry. Let me give some comment from your case. For the case one, in my opinion, China construction law state that this law can be applied once the project is in territory of PR China. So if Chinese company go out and conduct construction activity, any law can be applied depending on the agreement of both parties written in the contract. However, if no state anything in the contract, general practice will be applied. The contract should be made according to the rule of law of the country where project is located. Same with the Thailand Arbitration Act also states this, that if there is no other agreement, the construction in Thailand has to follow the Thailand law. For the case number one, I agree with you. For the case number two, this case, we have to use the principle of construction management and contract management. However, the principle of lump sum contract, single price is code for an entire project based on the drawing and specification and cover the entire project, and owner know exactly how much the work will cost in advance. However, the lump sum contract, the owner has essentially assigned all the risk to the contractor, who in turn can be expected to ask for the higher markup in order to take care of unforeseen contingency. However, in this article, I read you have some law that state with this kind of thing, but I'm not clear. In this one, if in generally the BQ that provided by the employer is for the fast track pricing, contractor shall reject remeasurement by using any technique such as the concrete ratio, rebar ratio, formwork ratio, etc., or re-estimating for the accuracy of the cost. If no other related information regarding this issue, I have a different opinion from tribunal. The contractor cannot claim for the additional payment arising from the quantity increase and vary work in a lump sum contract. I have the case number two, I have different opinion. However, for case number three, I do agree with the tribunal that the subcontractor had a reasonable defense for the failure to give notice of his claim within 28 days, as required by the subcontract, and was entitled to claim an extension of time. I also do agree that subclause 10.1 of the subcontract provide that if the employer grant an extension of time for the contractor, then the subcontractor shall enjoy an extension of time accordingly. In the present case, since the employer grant the extension of time with a total 4 months, it was clear that the subcontractor should enjoy the same percent to subclause 10.1 of the subcontract. So this is my comment. Thank you, Mr. Joe Tirado.
Thank you very much, Professor. And it just goes to show that when you're having fun, how time flies. We're already about halfway through our session. So unfortunately, I'm not going to be able to kind of follow up as much as I would have liked to have done. But one question I must ask, given that we're talking about construction, one of the most hottest debated topics during the last 3 years, as everybody will know, is whether or not the COVID-19 pandemic might constitute an event of force majeure. Now, of course, I realize that the answer will depend on the specific facts, contractual provisions, and of course, the relevant applicable law. But in that, and I'm afraid it's going to have to be pretty much a yes or no answer, Mr. Yun. I wondered whether you might be able to shed some light as to how Chinese law looks at the question of COVID-19 and whether or not it would generally be considered an act of an event of force majeure. Mr. Yun.
Yes, thank you, Mr. Joseph. And yes, your question is so challenging and so narrow. And however, in China, where the China law is applied, we have to pay attention to the judicial interpretation number 2 on the COVID-19 released by the SPC, the Supreme People's Court. It provides that unless the subject purpose of the contract shall not be realized due to the COVID-19, a party of the contract on the COVID-19 as the force majeure event shall not be supported by the court. And that is to say, the terminal, I call it the terminal legal test, or the baseline of the legal test as to whether the COVID-19 is the force majeure events or not, relates on the realization of the subject purpose of the contract. This is the China law, or the SPC rule, but the terminal legal test for the force majeure events on the COVID-19 relates on the purpose of the contract. And this test, in my humble opinion, is too rigid to become true, and thus it is very hard to say that the COVID-19 to be a force majeure event where the Chinese law is applied. However, we have to pay attention in a case in Singapore. The case number is the 2022-2022 SGHC Singapore High Court and A34 between the second two, if my pronounce the name is correct, with and GTMS Construction Private Limited. The Singapore High Court has ruled COVID-19 constitute a force majeure event in the construction contract. This is the first ever I found out in the construction sections that a court of Singapore High Court has ruled the COVID-19 is force majeure events. And I suspect the supposed the Singapore's decision will be cited in the case in the some other jurisdictions, like particularly the common law, jurisdiction like England or other common law countries. And we have to pay attention. There's one case law has been appeared in by the Singapore High Court, and will be given some guidance on the upcoming in cases regarding the COVID-19. So this is my answer to you. Thank you very much.
Thank you, Mr. Jun. Forgive me, we will have to, I think the answer was under Chinese law, at least as I understood it, was probably not that be considered, but it's interesting the case you've referred to in Singapore. My apologies to Mr. Zhang, Mr. Wong for keeping you waiting, but Mr. Zhang, if I can head over to you next, we're going to move over to the second half of our session, which is dealing with energy dispute resolution. Again, like Mr. Yung, we're extremely fortunate to have Mr. Zhang with us, as he's the author of the chapter on energy dispute resolution in China. So, Mr. Zhang, over to you. Thank you.
Thank you, Joe. And I'm going to take you through the annual review on energy dispute resolution in China for 2021. I was only given 15 minutes, so I will do this presentation very quickly. So if you look at the table, and you can see that energy dispute continued to be one of the dominant industry in all types of dispute in all major international arbitral institutions, including ICSID, LCIA, ICC, and the BAC. And let's look at the BAC statistics in 2021, and the number of cases filed with BAC in energy sector is 543 cases. And you can say that the new energy plus traditional energy account for more than 50% of all energy cases. And in relation to the aggregate value in dispute of the cases filed with BAC in energy sector, reached to 8.84 billion RMB. And still new energy take the lead in all these cases. Among other noteworthy trends in energy dispute resolution, I think we should emphasize one particular trend in the energy dispute resolution. That is, we see the Chinese energy companies cross-border commercial dispute increase significantly. And we have the following observation. And the first is that we see various types of energy disputes, from the traditional from the conventional petroleum upstream M&A disputes, and also production sharing contract disputes, plus new energy companies IP or joint venture disputes. And the second observation is that we do see the amount in energy dispute are quite huge, ranging from several hundred million to even several billion US dollars. And the third is that we see the parties usually select the major international arbitral institutions as their forum to settle the disputes. And the fourth is that not only the conventional energy company, but also the new energy companies, they are in a lot of dispute cases. So for the major law developments, I should emphasize that on 2021, we have the CPC and the State Council issued the working guidance for carbon dioxide peaking and carbon neutrality info and feasible implementation of the new development philosophy. Also, the State Council issued action plan for carbon dioxide peak before 2030. So this means that the country has established the policy system. So the two policy can be regarded as one, and after that, the industry-wise policy measures will be issued. So two critical milestones. The first is by 2030, the carbon dioxide emission will reach a peak. The second is by 2060, the goal of carbon neutralization will be achieved. Also, the Chinese judicial system very emphasized that the judicial shall be of the assistance for the energy transformation. So you could look at the highlighted case in this page. The court in the end has ordered a hydropower company to strengthen the environmental impact assessment in areas where they a critical endangered plant in that area before building the new powder station. Case study. So I will focus on the cross-border commercial dispute from Chinese energy companies, and the first one is China Hydropower Bidding Consortium. The consortium won a contract for the CFE hydropower project with a value of US 386 million. But after the contract was granted to the consortium, and the state power company didn't perform its obligations, which the land use necessary for the construction, as well as the local community, the blockage from the local community. So further delay the construction of this project. So in the end, the Chinese consortium raised applied to LCIA to rule on termination of the contract, recovery of fees, and various claims. The state power company claimed LCIA has no jurisdictions over the dispute, and the respondent claimed because in the arbitration clause under the agreement there is a carve-out which specified that all the technical and administrative issues shall be resolved by expert determination. And the state power company's position is that there is a carve-out in the arbitration clause. So all the issues in relation to technical and administrative matters shall be subject to expert determination. And also it argued the Mexico law provided that termination of the contract with public interest shall be determined by Mexico court. The tribunal decide that the state power, the state power company's position would be contrary to the universally accepted principle that prohibits states, including their production companies, which means CFE, from invoking their own legislation to avoid an arbitration agreement, what they themselves have proposed to a private party. And also, the tribunal revert to the wording in the contract because the technical or administrative issues can very much related to legal issues. So that should pass the jurisdiction to the arbitration. And the second case is a JV company by Arsenopec and CMPC, and it has an agreement with Occidental, and they jointly own an interest in an oil block in Equator. And the Equator government nationalized the oil block. Afterwards, Occidental raised exit arbitration against the Equator government for the nationalization of the oil block. But the exit tribunal decided that only the participating interest of Occidental can be compensated. So here's the problem. The exit tribunal ruled that the joint venture of the established by the two Chinese company can get compensation from Equator based on China and Equator BIT, but not the U.S. Equator BIT based by Occidental. So when Occidental get compensation from Equator government, which in the end they settled the dispute, they have different understanding of the contract. So the joint venture think any monetary award received should be shared by Andes. But Occidental's position is that any award representing both parties' interest shall be paid to Andes. So the tribunal, the tribunal's decision is that, you know, if the Chinese company, they can get compensation from Equatorial government, that's ideally, so everyone can get his portion of the compensation under the oil blocks. But it's not the case, so the tribunal must interpret the contract in accordance with its terms. So in the end, the tribunal ruled that Andes, the joint venture by the two Chinese company, shall be entitled to get compensation from Occidental in proportion to its participating interest in the oil block. So hot topic. The first one is the nature of carbon emission rights under Chinese law. We can say there, based on the draft of measures for administration of carbon emission trading, we can say the draft provided the carbon emission right is defined as the right to emit greenhouse gas into the atmosphere according to law. But on the official version of that regulation, the definition refer to the carbon emission credit as, you know, allocated to clean emission units within a specific period of time. So we can say the nature of carbon emission rights has not been officially settled under Chinese regulation. And the second is that the climate change litigation risk and ESG litigation risk faced by the energy enterprises. So we see a lot of landmark case under common law jurisdictions. We see we see under English law, you know, some energy company were held liable to its overseas subsidiaries for their breach of environmental laws. So that's a real exposure for the energy companies. And we also see that Shell was sued by some NGOs, and in the end, the court ordered Shell to reduce its emission by 45 by 2013. So that's the real exposure for the oil majors. But if you look at the climate change litigation in China, the climate change litigation in China focus on reduce the carbon dioxide greenhouse gas emission, and it's sort of tool to deal with the environmental breach towards actions. So under Chinese climate change litigation, there is no specific requirement of the climate change threshold. And the last one is that Anbang versus Mira. This was probably the one of the most important commercial cases in the last 2 years. And Anbang is a Chinese company, and Mira is a Korean company. And Anbang sold its 5.8 billion USD assets to Mira. So after the transaction, there was the breakout of COVID-19, and Anbang took some actions to close down the real properties, and in order to operate under the ordinary cost covenant. So the case brought us two critical questions. The first is whether COVID-19 constitutes a material adverse effect, and the second is that whether the ordinary cost covenant was breached because of the unprecedented steps Anbang took in response to COVID-19. So the Delaware Supreme Court affirmed the Court of Chancellor's decision, and say COVID-19 doesn't constitute MAC, because of the wording in the contract, and but Anbang did breach the ordinary cost covenant. So that gave a serious lesson to all kinds of companies in the M&A industry. We could say after that case, a lot of energy M&A transaction, when they do the material adverse effect drafting, they took into consideration of the judgment. So conclusion and concluding remarks, and we still see the increase of the climate change litigation, ESG litigation, and till September 2022, the number of climate change litigation cases increased to around 2,500. Also, because of the energy transition, we see there were more investor states disputes between the energy companies and the states. We not only see the conventional oil and gas companies risk the investment arbitration against the host country. We also see the new energy companies because of the decrease of the subsidies. There are a lot of investment arbitration cases going around. We also see that the Russian-Ukraine war bring a lot of disputes, especially by sanctions or export control, and we also see a lot of dispute cases already coming out between Russian and Ukraine companies, European companies, Russian, also those Western companies withdrew from Russia. I expect that the energy distributed energy industry will continue to increase rapidly, not only in conventional energy, but also in clean energy. So that's all my presentation. Thank you.
Mr. Zhang, thank you so much. I mean, lots to discuss and follow up with you. Sadly, limitations of time prevent me from doing that. Let me hand straight over to Mr. Wong. Thank you for waiting for us, Mr. Wong. If you can let us have your comments on the presentation we've had from Mr. Zhang. If I could ask you to please keep to time, because we're getting close to the end of the session, and I'll need to wrap up very shortly. Thank you, Mr. Wong.
Thank you very much, Mr. Tirado. Hope I got the pronunciation correct. For a great introduction. And thank you for the organizers, Beijing Arbitration Commission, for putting together such a great panel. And also I would like to thank Mr. Leslie Jiang for such a great presentation, giving us a really good summary of what is really happening in the energy industry for the past year, and also the ongoing trend. As Mr. Jiang has mentioned, there are a lot of hot topics in the energy industry with regards to disputes. For example, climate change, which has obviously been in the headlines for a couple of months in the past few years. The energy transition, which is a huge focus for everyone in the sector. The Ukraine-Russian war, which Mr. Jiang touched upon in his final remarks, sanctions, etc. So from what we have seen in practice, there's obviously a huge shifts from traditional oil and gas to renewables with the energy transition, which is still ongoing. And as you've seen in the presentation, the amount is slowly shifting from these traditional oil and gas oil and gas industry to renewables. So in terms of renewables, we would expect a lot of these projects are still in constructions. So a lot of these construction projects will come to completion in the near future. So at the moment, there could be construction type of disputes, price adjustments. There could be a lack of funding or liquidity due to the ongoing world economic issues and inflations. We've also seen various shareholders can't fulfill its capital calls, so there could be shareholders types of disputes. Supply chain issues with the availability of materials and supplies. This is particularly an issue in an offshore wind industry with the vessels for constructions, which are very limited worldwide. As the projects comes to completion, we expect there would be issues with the power purchase agreement, with PPAs, with change of law and stabilization as well, which is quite similar to what we've seen in the oil and gas industry in the past few decades with the PSCs. A second point I want to touch upon would be on the ESG front, which is a seriously hot topic for everyone. Some recent practical experience, in particular in Asia, is the ongoing focus and emphasis with regards to ESG due diligence, which we expect that would slowly shift from a transaction-based to a litigation risk. There are companies with ongoing focus with compliance with international standards, for example, the OECD Multinational Enterprises Guidelines, the UN guideline principles. These soft laws are not technically legally binding. However, they're reputational risk, and also for companies which are listed, you might have to comply with these standards anyway. You might also be affected with your financing, increasingly with banks who are increasingly looking to sort of have their reputation and image in compliance with these standards. We've also seen a lot of offtake contracts with hard termination rights. So this could trigger contractual disputes if you're not compliant with these standards. So these standards are quite vague and widely drafted. So in order to comply them, there might be yearly review as well with technical advisors. So last point I want to touch upon is obviously sanctions with regards to the world events. There's a huge shift in emphasis and focus in sanctions. The energy sector is interrelated globally. Chinese companies and some Western companies have huge investments in Russia. In the beginning of this year, we obviously helped a lot of companies to wind down a lot of their operations in Russia. So there is an increased focus in contractual drafting, how to cater for sanction situations, shift and changing in funding and currency mechanics to withdraw to comply with sanctions. Supply materials. There are recent cases where we're assisting various contractors and operators withdraw from Russia. Their suppliers which refuse to comply with their contractual supply and performing contracts due to EU and US sanctions. So these are the areas of focus and hot topics we'll continue to see in the next few years as well. So thank you again for the invitation. I'll hand it back to Mr. Joseph Tirado.
Mr. Wong, thank you so much for your concise commentary. We are running slightly over time, but we did start a minute or so late. So let me just conclude, if I may, by saying, I mean, we are obviously self-evidently living in a very challenging world. The pandemic, as I don't need to point out to our Chinese colleagues, is still very much present. The war in Ukraine continues, and we see no end to it. Impact of climate change grows ever more severe and urgent. I think I would just say that whatever solution or solutions is eventually found for each of these enormous challenges, China without doubt will continue to be an ever more important actor in making these solutions become a reality. And I think in the last few seconds, let me just thank the organizers for inviting me and my fellow panelists to present today. Let me thank our excellent presenters. There was so much information there. We could only skim the top of the waves. I thought they did a fantastic job in doing that and highlighting key issues for us. So thank you. And of course, thank you for to our audience for joining us from wherever you are. Apologies for the need to have to the speed we go through. And if I may just say that apologies to our next session, Gergis, I think we're about a minute or so over. So without any further ado, thank you very much to everybody.
Thank you, guys. Thank you, Joe. Thank you, Charles.
Yes, hello everyone. This is Gergis Abdel-Shahid. I'm the managing partner of Shahid Law Firm. I'm joining you from Cairo, Egypt. And it's an honor to be moderating this session with such an esteemed panelists. I have on the panel for discussion of a couple of interesting topics, Ms. Lu Qi. Ms. Lu Qi is the founder of FN Lager Corp. She is a regular seminar instructor on matters related to supply chain finance, financial innovation, of course, fintech, and IP in finance. Ms. Qi has various publications in finance and is currently working with the Oxford Press on translating the principles of banking law. Also, we have on this panel, Ms. Wu Ying, who is a partner of Tiantong Law Firm and has intensive experience in cross-border dispute resolution. She has represented many domestic and foreign clients with a wide range of disputes, including financing, international trade, joint venture, bank guarantees, and EPC disputes. Ms. Wu is the ICC YAF now with a AA, representative of North Asia. Also, Ms. Cui Jun Chi, who is the VP and General Counsel of Total Energies China. Before moving in-house, Ms. Qi practiced in multiple international firms and also sits as an arbitrator. Last but not least, we're joined also by Mr. Ernest Yang, the partner of DLA Parker, head of litigation regulatory, and who co-heads the international arbitration practice in Asia as well. He is experienced in handling international disputes, covering areas such as sale of goods and commodities, joint ventures, energy and offshore projects, international investment and technology across multiple venues. Ernest was appointed as a member of the Chinese People's Political Consultative Conference and now sits on the standing committee of this CPPCC in Shanghai since January 2019. I'm very humbled and honored to be moderating the session, and I give the floor to the first speaker, Ms. Liu Qi. The floor is all yours, Ms. Qi.
Okay, thank you, moderator. Nice to see you here. Okay, thank you for having me here. I'd like to divide my 20 minutes into 5 parts. I will try to, into 5 parts to report our observation over financial dispute in 2021. The first part is about the whole picture. I will cover 3 aspects. New features appeared in financial disputes, new changes in resolving them, and new resources to support the resolution. As to the new trends of financial dispute in China in the past year, we could never forget the requirements from central government, who demanded holding the bottom line of not to occur systematic risks, and to release them in order in multiple ways, including legal disputes. So financial disputes in 2021 is first about controlling financial risks and against capital expansion. We have seen continuous default events along the supply chain of real estate industry. We have watched the disputes arising from the correction over internet platform, some of which were at the edge of IPO and got the capital's way out blocked. And we also have experienced some new while strong administrative measures being taken, like antitrust, anti-unfair competition, anti-unauthorized financial activities, which eventually made some contracts avoid from the beginning or incapable of performance anymore. So let's come to the second dispute features. The second dispute change is caused by legal requirements on banks' non-performance assets. Disguised assignment over bad assets had been regulated strictly, and legal proceedings tend to be a prominent tool to dispose of sour assets, regardless of on or off balance sheet asset, and no matter they are from big or small functions. Furthermore, even for internal credit write-off, litigation has become a panacea for those involved bankers to protect them as a due process. And also in the area of bankruptcy, problems requires a uniform legislation in response to those failure market participants, like the insolvent-related conglomerates and the failed financial institutions, and as well as misfortune individuals who got bankrupt. Those are featured dispute in 2021. Okay, then to cope with them and to perform the central government's policies effectively, the ways to resolve financial disputes are accordingly adjusted. One problem is that both administrative and adjudicative powers were collectively used. In cases like Conmay Pharmaceutical, we have found heavy regulatory fine and first security class action and lengthy prison sentence all applied, while in asset management subsection, which has been called quasi-security field, rules were gradually unified by watchdogs and judges to comply with anti-rigid payment policy. On the other hand, the decisions over financial cases become more professional and better empirical, which was shown with stronger reasoning when dealing with hard while frontier issues like anti-rigid payment, penetrating approach, protecting financial consumers. And thirdly, we can see pro-consumer tendency has furthered in the determination of all security cases, banking card cases, as well as illegal fundraising cases. Fourth, we can see also unfiled financial practices studied to be negated by both regulators and judges, mainly aiming at hidden interests, ancillary charges, unfair remedies from standard terms, especially as those claimed in pandemic period. To support this change requires new resources. More special courts and tribunals have set up. There are so far 3 financial courts and 18 tribunals for financial cases nationwide. Moreover, diversified dispute resolution devices have established in cooperation with financial authorities. They are seeking to resolve problems from the source. That's the big picture of financial dispute last year in China. And my second part is rather simple because comparing to 2020's Civil Code, last year came out with rare, extremely significant legislation. Most new rules in financial area are to support the Civil Code, such as updated registration rules as of real estate, movable, and vehicles as well. The most prominent law deserving your attention is Personal Information Protection Law, which has been called Chinese GDPR. The law, along with other data rules, went into force in 2021. In my opinion, during the course of learning and applying these new rules, financial firms are inevitably to encounter more legislation in this regard. And further, at a judicature level, some rules had been established to protect financial assets from disguised litigation and to help dispose of hard-enforced equity collaterals. Some measures works at present. And my third part is of 6 leading cases reported in 2021. They are actually into 2 groups. The first stands for the newly typical judicial approach, and that is penetrating to the substance. And the latter shows legal expertise in resolving financial disputes. The first group of cases occurred in 3 financial subsectors. They are supply chain finance and trust business and financial lease function. All these 3 cases are determined to have taken a disguised transaction form while being real lending substantially. The target of such disguise is to evade guarantee authority or to claim higher charges. The Supreme Court decided all these 3 cases are disguised forms avoid, which consequentially deprived of certain profit of these financial houses and further threaten the validity of subordinate guarantee. This piercing approach is especially prevailing when performing the central government's policy targets. And the second group of cases are on financial new products and services. They are all occurred in high-risk area, and 3 issues have been discussed. They are the validity of ISTA netting settlement clauses. Well, if the damage has to be proven as premise when claiming default event has been discussed. And secondly, how to decide a commitment letter of makeup for the balance. Is it a simple contractual obligation or a guarantee substitute has been discussed here. And the third case for this group is of the scope of suitability duty on seller in wealth management business. When deciding such innovative cases, the judgment showed their subtle and detailed analysis by applying analog method to traditional and typical services, and eventually determined to respect both international conventions and mercantile intelligence. And limited to my time, I'm unable to go into details of these cases, and I have to go on with the following 3 hot points and hot topics. The first is about the protection system for security investors. We now have 3 varied devices for security litigation: the ordinary representative action, the special representative action, and the model judgment mechanism, and each has found its typical and influential case. The next step may focus on how to integrate them and to give each of them a full play. Well, the cost for investors, the possibility to launch a case, and sufficiency of protection should be nicely considered. And the second hot field is wealth management sector. We are happy to see the basic legal framework has been established, and the fiduciary duty has been recognized as a cornerstone which offered a key to resolve the high-volume dispute regarding emerging wealth management business. And the last issue I want to talk of is secured transaction over movables. The Civil Code has almost restructured the rule systems in this respect, and the uniform registration system to perfect secured interest is in operation, despite of some issues unresolved yet, like acquiring secured property with bona fide, secured devices still unregisterable, and some other issues still unresolved. But I think the whole legal system is making great progress. So after 3 years being trapped in COVID-19, we are still confident to have a better future in financial area. In recent years, we have seen some modification on related legislations, and in the near future, we may see those finance closely related legislation amended, like commercial banks law, people's bank law, and that kind. We may also have a new judicative trial minutes on financial disputes, which is in progress now. We may therefore expect a better environment to do financial business. So that will come a better future. So thank you for your time. That's my report.
Thank you, Ms. Chi, and thank you for this very informative 20 minutes. Before I have one question or two questions that I can compile in one, if you don't mind. But before saying that, I must say that I'm actually here not representing the Cairo Regional Center as a person sitting on its advisory committee. So I'm mandated by the Cairo Center to be coming and participating in this is a prestigious conference. Ms. Chi, you've mentioned the Chinese GPDR and ISDA. Contracts that are with financial institutions and persons, including myself or anything, are the breaches emanating from the GPDR arbitrable? Like, can we agree on, in the case of a breach of the GPDR laws, can any kind of compensation payable be a matter governed by arbitration? Similarly, in ISDA, are breaches arising therefrom arbitrable in China? Thank you.
Thank you for your question. So I try to answer your question one by one. First, as the Chinese version of GDPR, I think compensation has rarely been judged for financial institutions so far because there are not so many cases come out. And we can see some case on IT industry that has been judged to make some compensation. But as the damage for breaching or for violating the GDPR is unable to calculate it easily. So damage has rarely been seen in this regard. That's my first question, first answer to this question. And as ISDA, as you may know, ISDA usually under ISDA, people choose to apply English law or New York law. So there is rare opportunity for Chinese judge to try this kind of case. So, this case may be just a surprise for Chinese judge because the participant forget to choose the applying law. So China has this opportunity to use and to review ISDA rules. And in this case, the Chinese judge actually eventually to respect the ISDA rule and to respect the international convention. That this is a good trend for our financial business. Yeah.
Thank you very much, Ms. Chi, and thank you for answering my questions. And I now yield the floor to our next reporter, Ms. Wu. The floor is all yours. Thank you very much.
Thank you. I'm not sure everyone can see my PowerPoint.
I believe we do.
Okay, thank you. Thank you very much. This is the first time for the Tiantong team to participate in this dispute resolution section, investment dispute resolution. So at the start, we would like to clarify the scope of our report. Excuse me, I don't know if you can see, because the PPT from my side does not roll down.
We can see, I think, the cover page, which has your name and the title.
Yeah.
But yeah.
Okay. Investment dispute is not an independent course of action defined under the PRC law. It generally refers to all kinds of disputes related to investment. Among these, disputes over securities and loans have been covered by Ms. Liu's report just now. And this report mainly focuses on the domestic dispute resolution. Therefore, our report only focuses on two types of investment disputes. That is, disputes triggered by acquisition and holding of active interest or property shares, and the disputes arising from the investor's prescription of asset management products. Our report can be divided into 5 chapters, and here is my brief. First overview. In this chapter, we observed the developments in 2021 from 3 major aspects. First, the corporate law reform has stepped into a new stage, and foreign investment rules have continuously been improved. On the legislation level, the Civil Code, the interpretation of the guarantee, and other rules came into effect in January 2021. Those new rules on legal persons and the guarantee have a significant impact on the resolution of corporate disputes. In addition, in December 2021, the draft amendments to the company law, which proposed a number of changes to the capital regime and corporate governance, was released for public comments. On the practice level, courts in various places have released reports and typical cases on corporate-related disputes, which are quite helpful for the market to better understand the laws. With respect to foreign investment, there are several new rules, while safety and openness are still the key features. Second is the exit mechanism for market players has been continuously optimized. The legislation and judicial work on enterprise bankruptcy has been advanced steadily. It is particularly noteworthy that the first individual bankruptcy regulation was issued in Shenzhen Special Economic Zone, and in July, the Shenzhen court concluded the first individual bankruptcy case in which the individual obtained a chance to get out of the difficult situation and start a new life through the bankruptcy proceedings. In addition, in May 2021, the mainland and Hong Kong established a mutual assistance mechanism for insolvency proceedings. And in December, the Shenzhen court, granted the first application for the recognition and assistance of a Hong Kong liquidation proceeding. Third, the regulatory system of asset management business has been improved with clearer judicial standards. With asset management business booming, disputes between investors and managers are increasing. In a broad sense, the concept of let the buyer beware has been more widely accepted in judicial practice, and the standards have become more and more transparent. Nevertheless, we have to say that many tricky problems are still to be resolved, given the complexity of the transactions. In the second chapter, we introduced 5 new rules and regulations. Well, due to the time limit, I will not go into detail of each of them. First is about the company law draft amendment. The draft was released for comments in October 2021, and we observed 4 major developments. First, the draft improves the capital regime. For instance, the draft plans to introduce an authorized capital regime for joint stock companies and permit joint stock companies to issue different classes of shares. Second, the draft strengthens regulation on affiliate transactions and improves the responsibilities of directors, supervisors, and senior officers for capital maintenance. In addition, the draft proposed to establish a double derivative action system. Thirdly, the draft optimizes the corporate governance. For instance, it expands the types of directors and permits the company not to set up a supervisor or supervisor's board in certain situations. There are other significant amendments, such as expanding the shareholders' information rights, improving share transfer rules, and etc. In a nutshell, the amendment, once passed, will have a significant impact on the corporate disputes. Oh, the second one is the measures for the unified registration of security interests of movable properties and rights, which has been just mentioned by Ms. Liu. The measure was issued in December 2021 to improve the efficiency of registration and refine the provisions on the security registration process. First, we can see that the scope of registration is clarified. The type of security subject to the unified registration includes 6 common types of security used for financing. Second, the provisions related to the registration content are refined. In addition to the basic information, the parties may agree to incorporate the information such as the amount of the principal claim, the scope of debts covered by security, and etc. Third, the measures hint at registration risks. The measures emphasize that the description shall be adequate to reasonably identify the security property. Otherwise, the legal consequence caused by the inaccurate or inadequate description shall be borne by the parties on their own. Fourth, the measures specifies the term of registration at 1 month at the least and 30 years at the longest. The third one is about the SPC's meeting minutes on foreign-related commercial and maritime trial work. The meeting minutes has more than 100 clauses. Those related to the investment dispute are summarized here. First, the meeting minutes clarifies that the validity of the resolution made by an overseas company shall be determined according to the law of the country where the company is registered and the company's articles of association. Second, the meeting minutes specifies that unless otherwise agreed by the parties or prescribed by the laws of the country where the company is registered, director's signature on behalf of the company shall be deemed as an express of intent made by the overseas company itself, while the absence of the company's seal shall not affect the validity of such acts. Third, meeting minutes clarifies the rules for handling disputes arising from the dominant investment disagreements for foreign invested enterprises. In addition to the consent of other shareholders, whether the business scope of FIE is on the negative list is crucial. In addition to the above laws and rules, we also see a few provisions on private funds and documents for optimizing business environment. In summary, the key purposes of these new laws and the rules are clear. That is to improve and optimize the business environment and transaction efficiency. Well, in Chapter 3, we introduced 4 typical cases in different fields of investment. The first case is about fund. It is typical in that this case has established the rule that the liquidation result of a fund is an important basis, but not the sole basis to determine the investor's losses. That is to say, the investor can claim losses before the fund is liquidated if the investor has the evidence to prove their losses. The second case is about the shareholder's liability for debt.
Yeah. You're back.
Sorry, I think I just lost the signal. I don't know whether I...
But we hear you now.
Okay, I don't know whether where should I start, because I lost the signal. I lost the connection just now.
Yeah, if you can share the slide, I'll tell you whether this was the last one we had or the one before.
Okay, let me show you. This is the okay, I'm just talking about the case study. I'm not sure this is the last PowerPoint you have heard.
Yeah, I think you can start from the case studies from the beginning, yes.
Yeah, thank you very much. In chapter 3, we introduced the 4 typical cases in the different fields of investment. And the first case is about fund. It is typical in that the case has established a rule that the liquidation result of a fund is an important basis, but not the sole basis to determine the investor's losses. The investor can claim losses before the fund is liquidated if the evidence is sufficient. The second case is about the liquidator's shareholders' liability for damages to the company's creditors, concerning the issue of whether the trust company shall bear the shareholders' liabilities with this property. No clear rules were formed in the previous judicial practice, and there are different approaches. And this case lasted 7 years for the court to render the final judgment. The SPC's view is that the trust company shall bear the shareholders' liabilities with its property sounds like an alarm for the trust companies when they set up equity trusts and carry out equity investments. The third case is about whether the investor shall exercise the repurchase right within a reasonable period. In this case, the answer is positive. However, there is no simple yes or no answer. Rather, the courts shall balance the interests of different parties and make a judgment on a case-by-case basis. The fourth case is about providing guarantee. According to the case, if the company's sole director is also the legal representative, a shareholder resolution shall be requisite for the company to provide the external guarantee. However, it still remains to be seen whether such a judgment will eventually become a uniform rule. Due to the complexity of transactions, we have to say that there is no one-size-fits-all rule for all cases. That said, we note that the courts and the tribunals have been trying to find the way to respect autonomy and efficiency and balance the interests of different parties at the same time. While the good practice will definitely help to protect and boom investment. In chapter 4, we talk about suggestions for the company law draft amendment about VAM agreements and the nature of debt investment made in the name of equity investment. As introduced just now, the company law draft amendment has proposed a lot of changes, but it is still not perfect and it needs improvement. Next, due to the time limit, I will just talk a bit more about the VAM dispute. The VAM is the abbreviation of Valuation Adjustment Mechanism. It includes 2 forms. The first is performance-based compensation, including cash and shares compensation. The second is a repurchase arrangement, which is usually triggered by events such as the target company's failure to accomplish IPO as scheduled, or the target company's overly poor performance. In the past decade, the VAM dispute has been discussed a lot in practice. We appreciate it is unique in China because so far the companies cannot issue different classes of shares as those in the common law jurisdiction. Nowadays, the issue regarding the validity of the VAM agreement has been resolved, and the key dispute nowadays is about the performance, such as whether there should be a limit on cash compensation, whether repurchase and cash compensation can be claimed simultaneously, and whether the repurchase price and compensation shall be subject to the statutory cap on interest. In terms of limit on cash compensation, the discussion usually occurs when the target company's net profit turns negative. We hold the view that unless otherwise expressly agreed by the parties, it may be more reasonable to treat the negative net profits as 0 when calculating the cash compensation. And if the target company fails to achieve the targeted years for years, the cash compensation may have to subject to the cap of the investment amount. In terms of equity compensation, it is subject to the amount of the shares held by the obligor. The shortage may sometimes need to be made up through cash compensation. However, without an express agreement, the court or tribunal may hold the investor cannot claim cash compensation besides the equity compensation. Regarding the issue whether repurchase and cash compensation can be claimed simultaneously, there are different views in practice. Generally speaking, we should rely on the contract. If the contract provides a repurchase and cash compensation for different circumstances, but fail to coordinate their relationship, the cash compensation paid or to be paid need to be deducted from the repurchase price. Well, whether the repurchase price and the cash compensation should be subject to the cap on the interest, well, there are different opinions in practice. And our view is that equity investment is different from the loan investment. As such, the return rate of the VAM agreement should not be measured according to the standard loan interest rate. Regarding the nature of debt investment made in the name of equity investment, we think it is also unique in China. When determining the nature of the transaction, the Chinese courts usually prefer to ascertain the parties' real intention. Generally, the courts may consider the transaction as debt investment and apply the cap on interest if, for instance, the investor shall not participate in the targeted company's operation, or if there are other documents proving the party's real intention was to grant a loan. Well, in summary, throughout 2021, significant progress has been made both at the legislation and practice levels, but the investment models are still developing. There is always room for improvement in terms of the laws and practice. Well, due to the time limit, this concludes my presentation today. And thank you very much for your time.
Thank you, Ying. You've mentioned something quite interesting for me, at least, is that the corporate law in China does not authorize companies to issue different classes of shares.
Yes.
But my understanding is that this might be relaxed from the draft amendments as it's seen now, and it might happen that classes of shares will be allowed. So go ahead. Yeah, or let me, yeah. And what would be the impact of that draft amendment once passed on the VAM arrangement in the future?
That is a quite interesting legal issue because, like the VAM was, the agreement was set to take reference to those transactions in common law jurisdictions like the BVI, the Cayman Islands, UK, Hong Kong, and in those jurisdictions, the companies, including both like the limited liability companies and the joint stock companies, can issue different classes of shares in different rounds of financing, like Class A, Class B, or etc. Well, in China nowadays, only in some trial zones, like the joint stock companies can issue different classes of shares, but the company law, at the law level, there's no such express rule. So the amendment nowadays propose like relax that limitation. That means that is a positive signal to the investment. However, we also have to say that the relaxation is only occurs for the joint stock company. However, the limited liability companies can still not issue like the different shares of different classes of shares. We can see the limitation. However, I think the positive signal behind the logic of the amendment, that is to like improve the efficiency, to optimize the business environment, that does matter. We cannot make the progress, all the progress in one step. And that is my response. Thank you.
Thank you. And lastly, on bankruptcy, we've seen, for example, a couple of days ago or a week or so ago that China's Supreme Court has determined that courts are allowed to determine arbitration agreements inoperative in bankruptcy proceedings. So what is the impact of offshore insolvency? And the offshore insolvency in general is a big question mark for a lot of jurisdictions. What is the impact of that insolvency proceedings on domestic arbitration? Domestic here means Chinese arbitration, yeah.
Yeah, thank you very much. Because with the booming of investment, we see a lot of like SPVs and set up by Chinese companies or the Chinese investors, the funding shareholder who like obtain the overseas identity. They are ordered to liquidate overseas. However, sometimes the investment agreements are governed by the domestic arbitration. So that's quite interesting if these entities or the individuals were ordered to liquidate. So whether the domestic arbitration can still be commenced or proceed. We have handled such kind of cases. I think that's quite interesting because China has not signed a convention to universally recognize the legal effect of a liquidation order. So that it depends. So a tribunal has the power to decide. In our cases, the domestic tribunal did not recognize the effect of the foreign liquidation. So the arbitration still proceeds. However, I think the enforcement may be an issue in the future.
Yeah, thank you. I think China is not alone in the world in finding this to be a very complex topic and not understanding whether to regulate it through legislations or not. But on bankruptcy and others, we also have Ms. Chi, who has a couple of comments to that. So Ying, thank you very much for your presentation. And I now yield the floor to Ms. Chi, Katharina, the panel savior at the last minute. So thank you very much. And the floor is all yours.
Okay, thank you, the moderator. Well, I'm going to comment on the annual review of investment disputes in China, which was prepared by Tian Tong Law Office, because I'm more familiar with that report. Well, basically, I think the report was a very well qualified report covering a lot of key issues that are related to investments and disputes, from corporate legal issues, bankruptcy legal issues, foreign investment law issues to private equity investment, from overview to preview, and case studies, which contains a lot of knowledge and analysis for us to learn. Thanks, Tian Tong, for such a wonderful job. As the in-house counsel from a multinational company handling China investment, I would like to give some highlights on optimizing business environment, which was mentioned by the report. My first point is that is a foreign arbitration clause valid in the shareholders agreement of a JV company incorporated in China? Well, as an international oil and gas company, my company have set up a number of Sino-foreign equity joint ventures in China. And we noted that if we use our overseas affiliate to be the investor to sign the shareholders agreement or joint venture contract with Chinese partner, we are free to use any foreign arbitration institution for the dispute resolution under the SHA or GVC. However, if we use a wholly owned subsidiary incorporated in China to be the investor, we cannot choose an arbitration agency outside China because the SHA or the GVC is not a foreign related contract. And if such SHA or GVC use a foreign arbitration agency, the arbitration award to be made by such foreign arbitration agency might be unenforceable by the Chinese court. Therefore, such foreign arbitration clause is invalid in the SHA of a joint venture company incorporated in China, because under the Article 128 of the former contract law incorporated into the PRC Civil Code provides that the parties to a foreign-related contract may, according to the arbitration agreement, apply to a Chinese arbitration institution or another arbitration. And this clause has been interpreted in the way that the parties to a contract that is not a foreign-related contract can only choose Chinese arbitration institution and not any other arbitration institution. Such interpretation has been supported by a number of court judgments in recent years. My Paris colleague always asks me that, do we have solution to eventually use a foreign arbitration agency for the SHA or the GVC? I said, yes, we can choose a foreign company as a party to the SHA or signing the SHA outside China in order to have the SHA or the GVC to be considered as a foreign-related contracts. There are also some voices arguing that giving election of arbitration institution is based on the principle of contractual autonomy. So such freedom should be respected. We will be very interested in looking forward to seeing the development of the judicial practice in this area. My second point would be that a few points in the company law draft amendments mentioned by Tiantong in its report would help to solve trapped cash issues in foreign investment enterprises. The trapped cash issue is always a concern by foreign investors when they intend to make investment to set up legal entity in China. I see some proposed changes in the company law draft amendments to help resolving this issue, these type of issues. For example, the company law draft amendments proposed to establish a simplified capital reduction system. In certain situations, the company may reduce its capital in a simplified way without carrying out complete procedures such as notifying its creditors. These would be very welcome by the market players when they need to do so. The company law draft amendments also proposed to allow company to use capital reserves to make up their losses, where in the past, the company is only allowed to use after-tax profit or surplus reserve to make up their losses. So this means that the fund that the company can use to make up their losses has been expanded. So I see all these measures are very positive to address the market players' concern and optimize the business environment. Well, last but not least, I do agree with the conclusion of the report that the legislation and the judicial work in China on enterprise bankruptcy has been advanced steadily, such as optimizing the deregistration and the status modification registration system for bankruptcy enterprises, which make the exit mechanism be optimized for market players, including foreign investment enterprises in China. So given the time constraints, so the moderator, the above are those I want to share with the audience. Thank you so much.
No, thank you. And it's quite interesting that across the globe and across the oceans, it's the same problems that everyone is discussing and the same topics. So even around us and here in the Middle East, these are the exact same topics that we all discuss within panels and conferences. So thank you very much for your insight as an in-house counsel to a foreign investor doing business across the world. Thank you very much. And this takes us to the last but not least, Mr. Yang. Thank you for your patience, and it would be great that we end up this panel with your comments and presence. So the floor is all yours.
No, thank you, Gurgis. Gurgis, thank you very much for this opportunity. I'm very grateful to have the opportunity to participate. I've had the opportunity to read the annual report, and I must congratulate Ms. Yu Qi, Ms. Ying Wu, and your team for a very detailed, well-researched, and excellent report. So it's very incredible, very informative. So thank you very much for that. I entirely agree with you that there is a big recent trend of defaults and bankruptcy in the real estate sector. Everyone knows about Evergrande. I think a lot of law firms are involved in Evergrande, including us. But not only that, Golden as well, and the Pansutong Empire, a lot of developments in Hong Kong. But it's not just real estate, technology field as well. Everyone knows about FTX. And we have also been helping creditors in the proceedings in Delaware. But again, not only the real estate and technology sectors, also the media and entertainment sector as well. People might also have heard about the English Premier League and the issues with BP Live and the Suning Group, which we're also involved in. I thought I would mention that because it is the World Cup, so I thought I would mention football as well. But it is true, and I think for any legal jurisdiction or legal forum to develop its insolvency and restructuring jurisprudence, I think it is very important for that system to build up case law and practice to provide guidance on when the court in certain situations would order a winding up of a company, when it would approve a restructuring scheme, a restructuring plan, in what circumstances would it support certain orders or decisions of the liquidators, how it would proceed to trace assets and what transactions it would uphold. And because each situation is fact specific, there needs to be a body of case law. And this is where I think the annual review has been so helpful because of the analysis and the body of case law that has arisen in China. I would perhaps just go into one issue because I think a number of cases which both reports have covered deal with the issue of sham transactions. And of course, this is an important issue in both insolvency, but also general legal practice. And this is when the court would actually strike down a particular transaction as a sham. This is not the only basis on which it would do so, but is an important aspect. So I thought I would cover, by way of comparison, I've been asked to do this, to talk about the kind of the common law aspect, or how the common law, and by that I talk about England, Hong Kong as well, how they would approach the issue by way of comparison with China. Now, in the case of Snook and London West Riding Investments, a case back in 1967, a sham document or sham transaction has been defined as one where the parties intend to give third parties or the court the appearance of creating rights different from the actual rights and obligations of any, if any, that they intend to create. But the courts then go on in a case called National Westminster Bank and Jones, again, an English court case, to say that the courts are very careful before they make a finding that a document is a sham, because one, a finding of sham carries with it a finding of dishonesty. Second, the innocent parties may rely upon the genuineness of a provision or an agreement. Also, the court also puts great weight on the existence and provisions of a formally signed document. So in a Hong Kong case, a recent Hong Kong case of Arctic Development, the court gives further guidelines on how it deals with the issue of when it would consider a transaction to be a sham and void the transaction. First, the court says it is not restricted to examining the four corners of the document and may examine external evidence. The test of intention is subjective. The parties must have intended to create different rights and obligations from those appearing from the document and must also have intended to give false impression to third parties. The fact that the act or document is uncommercial or even artificial does not necessarily mean it is a sham. And also, the fact that parties subsequently departed from an agreement does not necessarily mean that they never intended the agreement to be effective and binding. It may be that the parties actually agreed to vary their agreement. So let me give you a case example of one that I've handled, which illustrates these principles. So in this particular case, I represented a global well-known retailer. It is a private arbitration. Now, my client concluded a contract with a supplier for the supply of consumer products. The contract contained, amongst other things, a clause requiring the products not to be made using child labor and to abide by my client's ethical standards. Otherwise, my client could terminate the contract. Now, the products were actually manufactured by another party, a factory separate from the supplier which my client contracted with. Now, my clients communicated directly with the factory purely for convenience to discuss the details of what was required from the products because the factory was manufacturing the goods anyway. There was limited communication between my client and the supplier with whom they contracted. Now, my clients discovered the use of child labor in that factory and then went on to terminate the contract and reject the goods. So I'll call my client A, the supplier with whom my client contracted would be B, and the factory which manufactured using child labor would be C. Now C, the factory, sued my client A on the basis that there was a contract arising from some kind of conduct through the communications and the instruction to produce the goods. But when my client sued B, B then raised the defense that their contract was a sham. And this was entered into for tax purposes to allow C, the factory, to export the goods to A through B. The true supply agreement, it was argued, was between A and C. Now, the arbitral tribunal in Hong Kong decided that the contract between A and B was not a sham. Such a finding would require the arbitral tribunal relying on the authority say compelling evidence that my client A subjectively thought its contract with B was not binding. A could not have thought that because the child labor clause was very important to A. It did not matter that the communications or the performance was between A and C and the presence of B, the supplier, was artificial. This did not mean that the contract between A and B was a sham. So just taking that on the whole, and I'm coming to the end of my allotted time, I think the kind of the principles applicable under the common law on these issues, and based on my reading of the summary of the cases, are quite similar. There is a need for evidence, and it is a high threshold and a high burden. But of course, in the appropriate situations, it would be possible to have a finding of a sham transaction. But I think ultimately, and perhaps by way of a concluding note, it is very important, especially with the global nature of the insolvency and bankruptcy proceedings, the global nature of this, that it is very important for common law practitioners to be fully aware of Chinese law and civil law, how they would view issues such as this, and vice versa, given the linkage and the need for insolvency proceedings nowadays to be quite global in nature. I would just end on that. Thank you very much, Georges.
Thank you, Ernest. What a fine ending to our session 3, and on the having it being done on time, I yield the floor to the moderator, Ms. Brenda Horrigan, for taking over for session 4. Thank you very much all, and I would like to thank everyone on the panel, as well as the organizers for having this organized. Thank you. Keep well.
Great, thank you.
Thank you, everyone, and welcome to the last panel. We will be speaking about dispute resolution in international trade and in intellectual property. My name's Brenda Horrigan. I'm an independent arbitrator based in Singapore. I am also on the executive committee of the Australian Centre for International Commercial Arbitration, ACICA, and I am here as their representative. I'm joined on the panel this evening by several prominent individuals, starting with Mr. Liao. Mr. Liao is a partner of the Hoda Beijing law firm with main practice areas of international trade and dispute resolution. He served as the leading counsel or participated in nearly 100 cases representing Chinese and foreign clients in international trade investigations, cross-border trade, and investment disputes. He'll be followed by Ms. Li Fengfeng, who is a partner of Li Fang and Partners. Her main practice areas include intellectual property and competition law. She's participated in many important litigations and arbitrations covering intellectual property, anti-unfair competition, and antitrust law, and serves as a legal advisor for numerous companies. She previously worked at the Beijing IP Court and Beijing No. 2 Intermediate People's Court for nearly a decade, presiding over cases including civil cases, commercial and intellectual property cases involving trademarks, copyrights, and patents. Our commentators this evening will be Mr. Jeffrey Benz, who is an accomplished international and domestic commercial arbitrator and mediator with a focus on entertainment, sports, and technology. He's a former general counsel of the US Olympic Committee, former counsel to independent film producers and directors, and a former athlete. He is on the Court of Arbitration for Sport Arbitrators and Mediator panel, and is frequently selected as a sports and entertainment arbitrator. He is also a professor at Pepperdine University Law School. Finally, but by no means least, Mr. Gary Benton, who is also an internationally recognized arbitrator with expertise in international business, corporate investment, high tech, telecom, life sciences, and emerging growth matters. His practice is focused on venture investment, technology development, distribution, licensing, infringement, trademark, trade secret, copyright, and patent, cybersecurity, and other disputes. He's handled hundreds of cases around the world and is on the panels of major international institutions. Gary is an adjunct professor of law at Santa Clara University. So I would like to welcome all four of you, and I will turn the floor over now to Mr. Liao for the first presentation.
Thank you, Brenda. Can my PPT be seen? Good afternoon and good morning, everyone. It fills me with great pleasure to present a brief picture for last year's international trade from the angle of dispute resolution in China. On behalf of our writing team, I would like to first of all thank the forum provided by Beijing Arbitration Commissioner, Beijing International Arbitration Center, who plays an active role in international alternative dispute resolution, especially in international trade area. The year 2020 saw an outstanding foreign trade growth for China. According to China's customs statistics, the total value of China's import-export trade in goods in the past year was RMB 39.1 trillion yuan, reaching an increase of 20.4% over 2020. The foreign trade growth was with a new record high scale and a steadily improving quality, which is hard to come, especially against the COVID-19 pandemic globally. From a global perspective, the COVID-19 pandemic continues to pose tremendous stress on the world trading system, causing distractions in global supply chains and accelerating trade tensions among some countries and regions. And also, this pandemic accelerating trade tensions among some countries and regions. International trade rules and application remain in a period of instability. Under this environment, there happened some notable events in international trade field. My brief report this afternoon may not touch upon them all in detail for the time restraint. The following, I will give an introduction presentation on the 5 respects. The first one is regarding achievements and hotspots in international trade agreements for China. The second is about building free trade zones and ports. The third one focuses on ensuring steady promotions of highly level opening up by safeguarding core development interests. The fourth part will show 4 typical cases. And lastly, remarks on hot topics and prospects will be made. So let's see the first one, achievements realized in the hotspots area last year. China continues its opening up in international trade by reaching more free trade agreements last year. At a bilateral level, the establishment of Regional Comprehensive Economic Partnership, RCEP, is a major achievement of global economic and trade rules reached by ASEAN countries, Australia, New Zealand, Korea, Japan, and China. RCEP established the largest region free trade agreement in terms of population and trade volume, covering 20 chapters, including trade in goods, trade in services, etc. RCEP is a modern, comprehensive, high quality, and reciprocal large-scale regional free trade agreement. The signing and the implementation of RCEP is the most important event in the construction of East Asia economic integration in the past 20 years. In April 2021, China formally deposited the instrument of approval for RCEP and became the first non-ASEAN country state to formally complete the approval procedure. At a bilateral level, the protocol of upgrading the China-New Zealand Free Trade Agreement was officially signed by the protocol. The China-New Zealand Free Trade Agreement will further open products markets like timber, paper, and other products to the 2 countries. And the trade rules such as rules of origin, technical trade barriers, and custom facilitation will be further optimized. In the area of investment, New Zealand will set a lower examination threshold for Chinese investors and confirm that Chinese investors will be given the same treatment as that of the members to the Comprehensive and Progressive Trans-Pacific Partnership, CPTPP. China-New Zealand Free Trade Agreement has been a model FTA between China and the Western countries based on mutual respects and benefits. I personally have the honor to participate in the negotiation of RCEP and the China-New Zealand Free Trade Agreement when I worked for the Ministry of Commerce of China. It's about 10 years ago.
and witnessed the multiple benefits to the concerned countries and the people brought about by the implementation of these free trade agreements. At the WTO multilateral level, with China's contribution, the success of domestic service regulation negotiation has also been the latest achievement of WTO rules negotiation in recent years, which marks the return of WTO rules negotiation function. In addition, the growing influence of international trade agreements, such as CPTPP and the Digital Economic Partnership Agreement, DEPA, is constructive to shaping future-oriented international trade rules. China is also active in applying to join CPTPP and the DEPA, showing its commitment to further opening up to the world. In the second part, we'll see domestically, China is active in building the Hainan free trade port and supporting the further opening up and development of the free trade zones. China continues the promotion of the legal construction in domestic free trade zones. From the legislative level, the official implementation of the law of the People's Republic of China on the free trade port of Hainan provides a legal basis for the development of Hainan Free Trade Zone. The Hainan Free Trade Port Law provides a high-level regulation in trade in goods, trade in services, for investment, and the temporary movement of natural persons, granting operations more market access opportunities and preferential treatment. In terms of trade liberalization, goods other than those listed in Hainan's list of prohibited and restricted imports may freely enter and leave Hainan province. In terms of service trade, cross-border service trade other than those on the negative list will be subject to the principle of consistency between domestic and the foreign ones. In terms of investment, a more simplified negative list for foreign investment and a more simplified special list for market access should be implemented, as well as market access commitments, granting greater facilitation to investors. In the aspect of the administrative system on the free trade zones, Hainan local governments can also be authorized by the State Council and the Department to implement the corresponding government functions. Hainan Free Trade Zone obtained the March Zone for further opening up and development with law permission. In the coming third part, it's about safeguarding national sovereignty, core interests, and ensure steady promotion of high-level opening up. Anti-foreign sanction laws was adopted last year. In recent years, we see some very few countries and organizations out of intentions of political consideration tried to distort and suppress China's development, especially in improving some so-called sanctions on relevant Chinese state organs, organizations, and natural persons in accordance with their own laws, in violation of international laws and the basic laws governing international relationships. The promulgation and enforcement of the anti-foreign sanction law are beneficial to countering the illegal and unreasonable attempts by these foreign sanctions. After the promotion of the law, China implemented counter-sanction against some individuals and groups from individual countries, strongly fight against the forced attacks and unfair sanctions. For the same consideration, upon the approval of State Council, the Ministry of Commerce promulgated the rules of counteracting unjustified extraterritorial application of foreign legislation and other measures. The main purpose of the counteracting rules is to protect the legitimate rights and the interests of citizens. And the citizens, legal persons, and other organizations of China by formulating remedies to deal with the circumstances in which the extraterritorial application of foreign laws and measures violates international law and the basic laws governing international relations. The above law and rules provide legal tools from the legislative level to safeguard the national sovereignty, security, and the development interests, as well as to protect the environment of further opening up, especially in trade area. In the fourth part, like the before annual evaluation, we selected several typical cases determined in the round last year. The first case is about European Commission's anti-subsidy award on investigation of imports of glass fiber fabrics originating from China and Egypt. The anti-dumping and anti-subsidy investigation cases have been a highly contentiously disputable area under the WTO framework, and many disputes have been subject to the panel and appellate body. In this case, the EC, European Commission, found that the Suez Canal Economic Zone provided actionable subsidies to enterprises in the jurisdiction, but concluded that the subsidies were provided by the so-called China public bodies. The European Commission ruling raises several highly disputable questions, like the application of the article on the responsibility of states for internationally wrongful acts is obviously inevitable, inappropriate. The line between international and the actionable, the line between international aid and actionable subsidy is blurred, and so on. The second case is about a dispute over an international goods sale contract determined by China's court. The issue is whether the force majeure exclusion clause applies to the contract in question. The court rules the contract in this question was formed between March the 27th and March the 31 in 2020, during which time the pandemic of COVID-19 was already a fact. Both parties should have foreseen the risk when signing the contract. Therefore, the sign and the performance of the contract in question did not meet the conditions of force majeure. The third case also comes from a Chinese court, which is about whether the providing of a letter of credit implies the implementation of a payment obligation, and whether a bill of lading can be used as the proof of transfer of ownership of goods. In the present case, the Shanghai court is of the view that the letter of credit was only the method of payment chosen by both parties, and the providing of the letter of credit was not the same as the completion of the payment obligation. Although the delivery of the bill of lading represents transfer of operation under application of the applicable Swiss law, it does not mean that whoever holds the bill of lading will of course enjoy the ownership of the goods. Whether the holder of the bill of lading obtains ownership depends also on whether there exists a reservation of ownership title. and on agreement on the transfer of property rights between the parties. The fourth case is selected from an arbitration award given by BAC. The main issue in this case are whether the claimant as the shipper has the right to claim for cargo damage, and whether the maritime declaration issued by the ship and the logbook paid by the ship constitute force majeure to exempt the respondent from liability. The tribunal held for the first issue, the claimant and the respondent had signed the contract on the carriage of goods, and the claimant is under the contract rather than on the bill of lading to raise the claim against the respondent, so has the right to claim the cargo damage. For the second issue, the wind level at sea was one of the main contents of the weather forecast available to the vessel, so the force 8 wind was not a weather condition that could not be seen. The wind registered in the logbook did not have the legal elements of force majeure and did not constitute a legal force majeure event. Of course, for analyzing these cases, it should be reminded that the conclusion in specific cases have to be considered against a specific case, specific circumstance. Different or changing factors may lead to different conclusions. The final part 5, we'll see some hot topics and prospects by outlook next year. Last year was observed that global pandemic was repeatedly fluctuating. Economic recovery has become more divergent. Some major economic powers, like the United States and the EU, have accelerated the introduction of manufacturer relocation plans, accelerating local layout of industry chain and the supply chain. On top of that, the global supply chain are facing a new round of reconstruction, and the trends of reorganization, and the short chain have become prominent. Looking forward, in the field of international economic and trade rules and the international trade dispute resolution, key areas and issues for the new year are expected to focus on the following. At the WTO level, the reform development of multilateral trading system is an import topic. The post-dynamic era, the reform of the multilateral trading system and development of international trade rules have become increasingly important for the economic recovery. However, with respect to the reform of the WTO, no obvious progress has been made among key members, especially the US, which has not put forward a clear proposal to reform the appellate body, which have been in paralysis for nearly 3 years. And second point, new trends in domestic trade rules in major economic members. The US and the EU have tried to incorporate some so-called fair market and fair competition subjects into the traditional trade law. The EU has initiated concept of major distortion in its trade remedy rules, and has also tried to address a range of issues, such as state-owned enterprise and state subsidies in trade rules. These issues often fall outside the traditional setting of trade rules. Their compatibility with existing rules could lead to more trade disputes. Third point, is about new issues in trade rules. In the future, the carbon emission may be an avoidable issue affecting international and domestic trade in goods and services. EU has launched a legislative proposal on established carbon border adjustment mechanism, CBAM. And the carbon tariffs are gradually become known and may become an important factor restricting the development of international trade and the distribution of international investment. Finally, I want to conclude my report by thanking my partner who participated in completing the international trade chapter of this year's review. They are Mr. Yu Ziguo, my former colleague at MOFCOM and a current partner at Zonglun Law Firm, and Ms. Zhou Yarui, my current colleague at Telltale Law Firm. Thank you all. Thank you for your attention.
Thank you very much for a comprehensive and very interesting report. In the interest of time, I think we'll move on now to Ms. Li for her report. Ms. Li, the floor is yours. Ms. Li. We seem to be having a technical issue. Ms. Li? Ms. Li, we can't hear you. We heard something, but it doesn't appear to be. Can you try again? We can see the slides, but not hear you. Ms. Li, can you try again?
Brenda, this is Tony speaking. Yes. Can we move to the commentation for international trade first?
Yes, please. Can the commentator pick up, please? Sorry about that, just to throw it to you.
That's fine. Are we commentating as between Gary and I on both topics, or am I just doing international trade, or what do you want me to do?
Whichever you prefer. You can comment on both or one, whichever, however you had planned your remarks.
I'll take a stab at both. Ni hao to my Chinese friends, Xiao Wu hao. And Zhao Shahao here in Europe and the United States, and in Australia, good evening. Thank you for having me here. I will try to comment at a very high level and keep my time as best I can, given that we've split this in half to what has been allocated. I would say that, first of all, as I always do when I read this volume that's put out by the BAC and the BIAC annually, I learned quite a bit about Chinese law, most of which is very difficult to access in English. And so this is no different on this fine report that's comprehensive that's been put together by Mr. Liao on the topic of international trade. In some ways, while it is comprehensive, it is also depressing to read because one comes away with the sense that despite recent efforts in the world to come together over the past 50 years, we are further apart than we've ever been. And I can address some of this from the perspective of both US legal concepts and UK legal concepts where I'm admitted as a barrister. But focusing on the US relationship, US-China trade has expanded or exploded really in the 2 decades since China joined the WTO, and it's benefited, I believe, everybody, US and Chinese consumers and companies. But the different systems in that development have created tensions in various ways that have led both sides, I think, to push back in their own ways to seek their way forward in the world. It appears to be a positive step forward that China is now seeking to accede to the Comprehensive and Progressive Agreement for Trans-Pacific Partnership. And I only wish the United States would consider doing so as well, having withdrawn in 2016 from that group after first spearheading the ideas. Looking at the recent updates to Chinese law on addressing domestic responses to the actions of foreign governments on trade and sanctions and the like, that is not a surprise, I think, to those of us that practice our trade outside of China. Those are very common sorts of concepts and provisions that we have in domestic law and have had for a long time in domestic law outside of, or on the trade front. I noted the case in particular that was referenced and described on the European Commission investigation into government subsidies provided by Chinese public bodies to the Egyptian government in the area of glass fiber related exports. And I think that in reaching this decision, the European Commission used fundamental international conventions to interpret the WTO agreement on subsidies and countervailing measures. Interestingly, our authors today take issue perhaps with the Commission's use of some elements of customary international law as aids to interpretation, but they rightly point out that there is risk to Chinese businesses in the EU now as a result of this case. And I think that Chinese companies looking to move into the rest of the world always need to be conscious of the various trade rules, particularly under the WTO agreement and positions taken by various trading blocs. I noted with interest the examination of certain cases by the author concerning a concept with which we have all become familiar following the pandemic, namely the application of the concept of force majeure to excuse performance under an agreement. The main lesson from these cases that I've learned from my own service as an arbitrator and also advising clients is that the inquiry into force majeure is very fact specific. And depending on your legal tradition, it might be handled in different ways. So for example, in common law jurisdictions, force majeure requires specific contractual agreement to apply, as it usually does not apply as a matter of law. This somewhat reflects the bias of the common law in favor of the performance of agreements. And there have been a number of cases that I've been in where the list of potential force majeure events in an agreement may not have covered the concept of pandemic, disease, or epidemic, such that force majeure as a defense to performance has been found to not apply. So there's been, I think, massive wholesale rewriting, re-review, and rewriting of force majeure contracts by companies around the world, and specifically in jurisdictions where they may be subject to common law principles on force majeure. I enjoyed the discussion on the issue of letters of credit in international shipping transactions and how those work from a Chinese perspective. I really have nothing to comment on there except to say that I think there's a large body of law that is developed in this area around the world, some of it custom and tradition, some of it based on ICC and other related guidance. And I found it fascinating to be able to read about how the Chinese view of that might equate with or differ from the way it's dealt with otherwise. So I have nothing else really to comment on this issue, and I think I've taken my time. Thank you.
Thank you very much. I believe we now have Ms. Lee, and we can turn over to you for the intellectual property discussion.
Okay, sorry for internet problem.
No problem.
Can you hear me? Can you see my slides?
Yes, to both.
Okay. Okay. Good afternoon. I'm Li Fengfeng, partner at Li Feng and Partners, a full-service Chinese law firm. It's a pleasure to meet all of you online. Li Feng and Partner is fortunate to have this opportunity to write the annual review of IP dispute resolution in China for 2021. Today, I will share some highlights from that review. My presentation will consist of 4 parts as shown. Now let's begin with part 1. In recent years, there have been 3 trends in IP that deserve attention. Firstly, there were some changes in numbers of granted IP rights. Secondly, there were some remarkable achievements in IP legislation, which involves the civil code, patent law, and copyright law came into effect, and the revisions of relevant legal documents. Thirdly, diversified dispute resolution methods are constantly enriched, with litigation as a main theme, supplemented by mediation, arbitration, and conciliation. Regarding arbitration, the number of IP cases and the total amount of BAC for 2021 is still remarkable. It can be seen from the aforesaid aspect that IP protection in China is further strengthened. Now let's begin with part 2. Through this part, I'd like to share 5 typical cases from 2021. In our first case, the plaintiff claimed copyright protection for the acrobatic work involved, while the defendant stated that the acrobatic show they performed was a traditional art and not an original work. Therefore, the issue is whether the acrobatic show involved constitutes work under copyright law. The court held that although the main expression of the acrobatic show is traditional art, the movement design reflects the individual choices of the creator, thus constituting a work under copyright law. The second case involves open source protocols. The defendant used the open source code under the GPL third version agreement in the software it released. The plaintiff, the owner of the open source code, claims that the defendant did not disclose its source code in accordance with open source agreement. So it was not legally authorized, and the defendant's behavior constitutes copyright infringement. The defendant argues that it had obtained a license based on open source protocol and did not infringe the plaintiff's rights. The main issue in this case was whether the defendant has infringed the plaintiff's rights. In final judgment, the court supported the plaintiff's claims. This is a milestone case in open source software disputes handled by Chinese courts. In this case, the court made it clear that the open source protocol was a contract, confirmed its legality, and also recognized the highly scalable of the GPL third version agreement. That is, recognize that derivative works and modifications of open source programs under the GPL third version agreement are also required to make their source code available under the GPL license, and that the defendant shall disclose the full source code of the infringing software. The third case involves technical secrets. Fu was an employee of the plaintiff and was able to access the technical secrets in the case. However, Fu signed a technical cooperation agreement with the defendant, Wang Long Group, promising to provide the technical secrets involved. After that, Fu resigned and worked for Wang Long Group, fully using the plaintiff's technical secrets. The plaintiff then filed suit arguing that the 5 defendants had infringed their technical secrets. This case was a complex dispute over the infringement of technical secrets. The Super People's Court found that the technical information involved constituted defendants shall and severally compensate plaintiffs for their economic losses and the reasonable cost of right protection. ICPC's judgment reflects the spirit of making meticulous judgment and is of typical instructive significance to the calculation of damages in complicated technical cases.
Ms. Lee, you're on mute.
Okay. Now, can you hear me?
Yes, thank you.
The first case involves the punitive damages in trademark case. Before this civil lawsuit, the court made a criminal judgment and wrote that the defendant staff has counterfeited the registered trademark and shall be imposed a criminal fine. Can you see my slides?
No.
Oh, sorry, wait a second. Now, can you see it?
Yes.
Okay, sorry. Before this civil lawsuit, the court made a criminal judgment and wrote that the defendant staff have counterfeited the registered trademark and shall be imposed a criminal fine. In determining the amount of punitive damages, the fact that an administrative penalty or a criminal fine has been imposed for the same infringement does not constitute a reduction reason of punitive damages, but can only be a consideration in determining the multiplier of punitive damages. In this case, defendants had obviously malice and committed serious infringement. The court judgment reflects the court's attitude towards cracking down on IP infringements and the court's stress to protect IP rights. Now let's see the last case. It's about traffic hijacking. In this case, the defendant used the technical means to hijack the plaintiff's traffic into its own by forcing a target job by influencing the user's choice. Both courts in this case focus on the fact that although there is no direct competition between network service operators in different industries, there shall be in direct competition between them, for they are competing for network traffic. The court found that defendants' behavior not only damages the traffic interests of other operators, improperly increased their own transaction opportunities, and destroys normal market competition order, but also violates users' right to know and the right to choose of their own transaction behaviors. This case shows that the court has gradually increased the consideration of the consumer's interests in current internet unfair competition cases. The next part involves the hot topics that we selected to illustrate IP development. Disputes over ICPs have been a hot issue globally in recent years and a major problem for many ICP owners. China, as one of the major markets, has a high incidence of ICP litigation, and the Chinese courts are playing an increasingly active role in adjudicating ICP cases, making many innovative and useful attempts to make their own contribution to solving the world problem of ICP disputes. In recent years, Chinese courts have made many anti-suit injunctions and jurisdiction awards in ICP disputes. Problems such as the legal nature of French statements and the law-arm jurisdiction of Anglo-American courts remain unresolved. The PRC courts are participating in the global ICP dispute governance system on the basis of safeguarding the fairness and justice of domestic ICP dispute cases, protecting the PRC court's jurisdiction from being infringed, and respecting the principles of international comity. But there is still a long way to go and needs to be explored in practice. The next issue I want to share is regarding pharmaceutical patent protection. Since 2021, there have been many rounds of heated debates on pharmaceutical patents in both theoretical and practical circles. As a special commodity that affects a country's livelihood, pharmaceutical has become a key area of IP regulation. CNIPA SPC successfully issued relevant documents about pharmaceutical. Regarding the judicial practice, the first lawsuit over pharmaceutical patent linkage was accepted and heard. The Beijing IP Court examined and accepted the case, arguing that the plaintiff's claim met the conditions and the requirements of pharmaceutical patent linkage litigation. Regarding the academia, the focus has shifted from the feasibility of pharmaceutical patent linkage and pharmaceutical patent term compensation system to implementation and improvements of those systems. And scholars offer a wealth of valuable advice on improving the system. Here comes to our third topic, governance of short video infringement and IP protection. At present, short video has become one of the most important interactive methods for internet users. The copyright disputes relating to short videos mainly center on the secondary creation of short videos. Regarding the originality determination of the secondary creation of short videos, the judicial practice and academic research in China show a united front. The duration of a video is not a dispositive of its originality. It is necessary to make a comprehensive judgment based on whether the arrangement, selection, and presentation of the specific short videos reflect the unique value. How to determine whether The secondary creation of a short video constitutes fair use of the original work has become one of the hot issues. Both academic circles and the judicial practice have explored this issue. When considering whether an act is a fair use, it is important to focus on the legislative intent of copyright law and the purpose of the fair use defense. Regarding the liability of short video platforms, in China, the safeguard harbor principle is mainly applied to determine whether a short video platform has subjective fault so as to judge whether it constitutes infringement. The red flag principle shall apply to some obvious infringements that the short video platform knows or should have known. On 5th December 2021, a new rule was published. It clearly prohibits the second creation based on audio-video programs, but how to implement in practice remains to be seen. The last issue I want to share is regarding personal information and data protection. The past year has been a crucial year for the construction of a personal information and data protection system in China. With the effective implementation of the Civil Code, the Personal Information Protection Law, Data Security Law, and a number of related regulations, data protection, especially personal information protection, is gradually receiving more and more attention. The system for the protection of personal information has become relatively well developed in response to practical needs. It is foreseeable that the types of cases seeking civil remedies under personal information protection law will gradually emerge. This also suggests that companies whose business involves data capture, and in particular, the collection of personal information, will henceforth need to pay extra attention to potential infringement of personal information rights and interests. Now, I will summarize the key points of this presentation and make some predictions. We can see that China's IP legal framework was greatly improved during the whole year. However, changes exist. New industries and technologies are bringing complex issues. To handle this, we may try to consider the balance between innovation and protection, develop theoretical framework in response to legal practice, and promote the efficient settlement of IP disputes. That's all I want to share today. Thank you very much for listening. I hope that there will be more opportunities to exchange ideas with you in the future. Thank you.
Thank you very much. That was very informative. In the interest of time, can we now turn to Mr. Benton for your comments, please? Thank you.
Thank you very much, Brenda. Hello, everyone. Ni hao, wang shu hao to my colleagues in Beijing. It's very good to be with all of you. I'm going to keep these comments brief because I know we are short on time, but it is really wonderful to be back with so many old friends, even if we cannot be together in person this year. I do remember just before the pandemic, the summit was held in California, and we do welcome all of our colleagues from Beijing back as soon as you can join us. As Brenda mentioned, I'm a US-UK international arbitrator and the founding and current chairman of the Silicon Valley Arbitration and Mediation Center, among other roles. And my practice is largely focused on cross-border technology-related disputes involving China. My friend and former partner, Mr. Tao, noted at the start that it is very early in the morning here in the US. In fact, it's 3 o'clock in the morning here in Silicon Valley. but it's worth little sleep to be with all of you. So my thanks to Dr. Chen and his associates at the Beijing Arbitration Commission for inviting me to join you again. The speakers in the first session had addressed how China has made important advances in international arbitration in the past year, particularly legislative advances. And BAC's annual review is, in my view, the best resource of many of the new developments in so many sectors. Let me comment briefly on the excellent reports on IP by Ms. Li Fengfeng and trade by Mr. Liao Ming. My other old partner and colleague, Mr. Benz, has really covered so many specifics. So allow me to address 4 points at a very high level, starting with IP. Emphasis has been made on the People's Republic of China court focus on spearheading a global governing system over SEPs, standard essential patent licensing disputes, and IP more broadly. And certainly the PRC has developed a speedy and efficient mechanism for resolution of IP disputes. They offer, in many instances, a useful alternative to often lengthier and more detailed Western common law mechanisms, particularly at a time when international borders are closed, trade tensions appear high. The possibility for global governance is an important goal. And in achieving that goal, I would urge that all states continue to work to allow parties to resolve disputes in international arbitration forums around the world and to provide deference to the decisions of properly constituted foreign tribunals. Point 2 to make. One continuing impediment that we really haven't addressed, but we must acknowledge in IP arbitration, is that some jurisdictions, including China, limit arbitration of patent validity disputes. And this is understandable, as patent validity is a matter of state right. However, consideration should be given, in my thought, to the opening of arbitration validity disputes as between the parties. I won't belabor the point, but only suggest that doing so will allow full and efficient dispute resolution in a single arbitration forum and will strengthen international IP arbitration in China. Let me turn to trade very briefly. On trade, I note the discussion on anti-foreign sanctions law, and there have been excesses, and some would argue in both directions. But I think we would all agree that multilateral assessment of issues often yields the best results. The trade report mentions new issues in trade, labor and carbon controls. And here again, I would suggest that multilateral initiatives to address basic rights, to address the global environment will serve best. And I would hope that China and the West will work together on these very critical matters. Finally, let me close by returning to my mention of trade tensions. Despite political differences, the US and China remain major business partners, and both countries are bound together through those business ties. There is a common joint interest to support global stability. International arbitration is an important component of trade and stability, and global stability is really integral to everyone's health, our welfare, our happiness. And the US and China share this goal. And I am confident that the US and China will work to maintain ties and friendship for the future. Let me thank and congratulate the Beijing Arbitration Commission and all of the authors of this year's report. The report is really excellent and speaks well for all. Thank you very much.
Thank you very much. Mr. Benz, do you have any last very short comments on IP?
Gary has covered my top level stuff. I would only add that if people outside of China want to understand what's happened on the IP front, they really need to pay attention to the amendments to the Civil Code. Not only did it affect issues with respect to trademark, copyright, and patent, but it also created a right of publicity, as we would call it in the United States, or an image right for individuals in their name, voice, image, signature, likeness kind of thing, as was noted by my co-author and I in last year's article in this single volume, in the article on sports dispute resolution in China. So I thought that that's a fundamental issue here for those that want to become knowledgeable. I really enjoyed reading the summary of the acrobatic case, which is very much similar to cases that we've had in Western jurisdictions in various ways over time. Since at least 1978, the US has recognized that choreography and pantomime are included in our copyright law. And in the UK, it was recognized since 1911. I don't know what that says about this issue, but it's an interesting topic, and thank you for including it. With respect to the SEP issues, it's a very difficult issue on the governance of those patents. I know Oppo, for example, has recently had a high court ruling in the UK go against it on that front. And until we get universal approaches to that issue, I think this is going to continue to be a problem for fundamental technology licenses for companies around the world, as hopefully the world will find a multilateral approach to resolving those topics. That's all I'll add on the top line. I'm sorry it was so scattered and dispersed, but thank you very much again to Dr. Chen and the BAC for having me here, and I'll be quiet.
Well, thank you very much to all of the presenters. Very informative, very useful. I will simply conclude by also thanking BAC and all of the organizers for putting together a very topical session for today. And I will now hand over to the closing remarks. Thank you.
Thanks to our moderators.
Thank you.
Thank you.
Oh, hello.
Can you hear me?
Yes, Dr. Colin.
Okay, thank you. So first of all, I'd like to congratulate the Beijing Arbitration Commission and Beijing International Arbitration Center for successfully hosting and concluding this 2022 annual summit on commercial dispute resolution in China. Thank you very much for inviting me to speak and to close this esteemed event together with Ms. Teresa Cheng SC, who shall be giving the closing remarks. The conference included speakers who delivered 8 papers in what were very interesting discussions focusing on the annual review on topics such as commercial arbitration and mediation in China, construction and energy dispute resolution in China, financial and investment dispute resolution in China, and trade and IP dispute resolution in China. All of the papers were very well researched and informative. All of the speakers clearly spent much time to put their respective presentations together. So again, I also congratulate the Beijing Arbitration Commission for its new publication, Commercial Dispute Resolution in China, an annual review and preview. I shall now try to do a very high-level summary on some of the more important points that one can find from the different topics and papers today. I shall begin with arbitration and the new draft legislation that we've heard today. These include the Ministry of Justice's issuing the arbitration law of the People's Republic of China draft for public comment on the 30th of July, 2021. And the Beijing Arbitration Commission rules 2021 entered into force on the 1st of February, 2022. So the adoption of hourly rates for arbitrators' fees by the Beijing Arbitration Commission is also an important step in advancing the BAC and BIAC to move further into the upper sphere of the international arbitration space, which has been dominated by traditional international arbitration centers just outside China. And we've heard for the areas of construction about the coming into force of the Civil Code on the 1st of January, 2021, and the coming into force of the new judicial interpretation on construction contracts. So there are several issues, but on which I would like to comment on. But in interest of time, I would now very much like to introduce my old friend, Ms. Teresa Cheng SC, who shall be the last speaker and shall deliver the closing remarks. Teresa is the former Secretary of Justice of the Hong Kong SAR region of the People's Republic of China. And prior to her appointment as Secretary of Justice, Ms. Cheng was a senior counsel in private practice, a chartered engineer, a chartered arbitrator, an accredited mediator, and a good friend. Teresa, the microphone is now yours.
Thank you very much, Colin. Thank you, Colin, for those kind words. May I first thank the Beijing Arbitration Commission and the Beijing International Arbitration Center for inviting me to do this closing remark. It is a formidable task, given the abundant food for thought that our speakers, moderators, and commentators have provided us. If I'm to describe this particular summit, I think I would like to use 3 words: comprehensive, informative, and inclusive. It's very comprehensive because you can see the breadth and the depth by which the topics are covered, the various types of dispute resolution, the sectorial specificities of each type of disputes and issues that arise. It is indeed very informative because not only do we have updates on the latest situation, we also have summary on case studies and indeed the trend and the hot topic, and hence the preview in the report. It's inclusive because of the nationality inclusivity, the sectorial inclusivity, and of course the gender diversity, where we can see a good number of speakers from different parts of the world and from both the male and the female gender. So we're very fortunate to have such an excellent summit. And I think to describe this event as a summit is truly apt, not only because the report has been very well prepared with very rich content and prepared by experts, but also presented by excellent speakers who, I must say, and I notice for the first time in many conferences, all the speakers have been able to keep to their time, and therefore I will follow the very good traditions that has been set in this particular event, and I will try and finish on time. In the many discussions, I will of course try to be succinct and will not repeat what the speakers have said, but perhaps what I feel I wish to echo and highlight. On the developments of arbitration in China, I think there are 2 very welcoming sights. The long-awaited arbitration law, we hope will be promulgated soon. And from the draft that we've seen, it is, whilst it is a domestic law for China arbitration, but it has already taken into account a number of the international practice. And I think it will enable users to look at arbitration in China with a new perspective and be more welcoming to use China as the seat of arbitration. The other very welcoming side is the opening up of the market to encourage foreign arbitral institutions to gradually set up in mainland China, and which will, I think, enable healthy competition and cross-fertilization. I think these are good signs of arbitration in China moving in the right direction. The presentation on mediation makes me think of 2 things. One is the importance of the one-stop service. I think that was the key that that Ms. Fang has highlighted as to the success of mediation in China. Not only do the national court system bring together the one-stop shop or one-stop service platform, the Chinese International Commercial Court, the CICC, also has a similar situation or arrangement. These arrangements actually also can be found in international practice. In the APEC collaborative framework for ODR of cross-border B2B disputes, they also use very much a one-stop shop type of platform, allowing for negotiation, mediation, and then arbitration to resolve disputes between micro small and medium-sized enterprises. And indeed, I think it's useful to note that the first 3 service providers actually are CTEC, the Guangdong Arbitration Commission, and of course also EBRAM from Hong Kong. So all these show that this tradition of China actually has an international echo to it. The other very interesting point that has been highlighted is perhaps the lack of legislation or lack of soft laws in the mediation regime. And insofar as this particular aspect, I'd like to highlight that in the Greater Bay Area, there is a joint conference of governmental organizations that have been set up, whereby the code of conduct, the accreditation standards, as well as looking at the overall principles of the rules for mediation are being reached in that particular platform. And it may therefore be a useful platform by which we can all look at. The importance of mediation cannot be understated. And I think multilateral discussions, indeed among states, in order to find a consensus will be very useful for the whole community as a whole. When we come to the sectorial differences or the sectorial discussions, the elephant in the room is being brought out, COVID-19. COVID is now obviously one of the topics, no doubt, being raised in many, if not all, of the disputes that are being brought up. Is it force majeure? Is it material adverse effect? How does it affect construction and energy disputes, but also global supply chain? They will all depend on the facts of the particular case and, of course, also the law of the relevant jurisdictions. But one thing I think we may all need to think about, and I put it as a question and no more than that, do we take it as judicial notice, or do we need some sort of form of proof in order for the effects of COVID to be proven? So it would be a question, I think, that will be discussed. Another questions that have been raised in the energy and construction section 2 is the climate disputes, climate litigation, as well as the ESG compliance. I think they will ultimately continue to feature in the discussions that we will have, and I think it will become something very important. When we come to the financial and investment situation, one of the topics that's discussed, and again, something I echo with, is the importance of an exit mechanism when it comes to investment. And it was mentioned about the bankruptcy arrangements or the insolvency arrangements between Hong Kong and the mainland. And I think I'm very proud and happy to say that Hong Kong is the only jurisdiction in the world that has a mutual recognition of and assistance to bankruptcy proceedings between Hong Kong and the mainland China. And I think this will allow the liquidators and professional liquidators to carry out compulsory winding up, as well as debt restructuring between the two jurisdictions. And I think that is a very important feature for the investors to bear in mind. When we come to international trade, the Hainan Free Trade Port Law was mentioned, and it's particularly relevant. I think Hainan may become one of the freest port in China, in mainland China. And I think one of the things that you look at in that particular law is that it actually encourages what one would call 立法先行. In other words, you legislate and then proceed, as opposed to most other free trade zones, which is 先行先试. So it's a tryout. So I think the Hainan regime is likely to give more predictability and foreseeability for businesses, and therefore attract a number of investments. And so I think that that's something that's noteworthy. Now, when it comes to the IP, I think the cases that have been presented highlight to us the excellent work that the IP courts in China have been carrying out in these last year, but also in the few years ahead. I think the IP court in China has become very specialized and handled many major IP disputes including the use of new technology and therefore new complex issues that have arisen. And I think the succinct summary that has been provided already give us a very good highlight on how IP disputes are being resolved, and no doubt also therefore reflecting on dispute resolution in the private sector, in the private alternative dispute resolution scheme. So all these advanced concepts will have to be adjudicated perhaps at some stage in arbitrations, and the court's judgments will give a lot of reference by which arbitrators can then be able to look at. So finally, I would like to ask all of you to join me in one way or another. I'm sure you will all wish to thank the Beijing Arbitration Commission and the Beijing International Arbitration Center for the initiative that they took back in 2013 and the dedication and devotion that they have been providing all these years in preparing the excellent annual report and in putting together an annual summit that has allowed very fruitful exchanges and updates on the developments of commercial arbitration in China, as well as the laws that have been newly promulgated, and importantly, the case studies. Next year will be the 10th anniversary of this summit, and I really hope that we will be able to greet each other in person, and I look forward to seeing you all next year in person. Thank you very much.
Thank you very much for your succinct closing remarks, Teresa. I think you have wonderfully captured all of the key points that have been brought up by the speakers today. So I think we are out of time, and I think we've run past time slightly. So it falls on me now to draw this great event to an end. I would like to thank all of the speakers today, all of the attendees, and most importantly, the very hardworking officials and staff of the Beijing Arbitration Commission and Beijing International Arbitration Center for successfully putting together and hosting this annual summit today. So with that, I thank all of you again. Thank you very much. Bye-bye.
高老师，您可以准备开始了。
Good afternoon for participants from Asia and Southeast Asia. Good morning for participants from Europe, Middle East, and Africa. And good night for those who join us from America and Latin America. Since 2013, Beijing Arbitration Commission has organized this annual summit